or inhibit the flow of return or make up air into the HVAC system, serving the premises, and otherwise conduct all activities in the premises in a manner that prevents unusual moist conditions and mold growth. So the landlord appears to seem to care about a roof leaking, about water intrusion problems, about moisture, and about mold growth, at least in their lease and on paper. They didn't seem to care that much about it today, or they, at minimum, tried to minimize and see that wasn't really a concern for them. The next highlighted portion reads, the landlord shall perform all maintenance and repairs upon the structural elements of the building, the mechanicals, and the other portion, subsection D, it says roof of the building. So it's not in dispute that the landlord was required to repair the roof, maintain the building. I don't think the landlord has contended that. You're going to get a series of stipulations as exhibit number 4 that go out with you to the jury deliberation room. And you're going to have all the exhibits that all of the stipulations that the parties have agreed to. The tenants were required to notify the landlord with regards to repair and maintenance. They did. They notified them over and over and over again. Landlord seems concerned about this mold issue, but no matter how many times Rick and Denise told them about the problems, they got the same answer. They got just a turnaround and walk away from the property manager, who was supposed to be the point person handling these maintenance issues. It's undisputed that there were multiple leaks into their office space. It's undisputed that there were multiple ceiling tile collapses for years. It is undisputed that there was damage to Rick and Denise's computers and furniture. It's undisputed that they had to cover their computers with plastic. It was undisputed that the carpets were constantly wet. It is undisputed that there was a bad odor of moisture from all the leaks. It is undisputed that the carpets were never changed until the landlord prepared to rent the property. Then all of a sudden, for the new tenant, they get not a $100 carpet cleaning, they get new carpets. It's undisputed that the landlord chose to repeatedly patch the roof numerous times instead of replacing the roof. It's obvious the roof needed to be replaced, because eventually that's exactly what they did. They didn't want to incur that $200,000 expense that they showed you. They tried to use the cheapest method first. And I believe one of the jurors had talked about during voir dire that they had a tenant with some water issues in their floor, and the tenant immediately wanted to replace the whole floor. Well, I would agree with you, and I think Rick and Denise would agree, that's probably not reasonable. But after 1, 2, 3, 4, 5, 6, at some point, it becomes reasonable to say, hey, maybe the carpets need to be replaced rather than just need to be cleaned. It's not disputed that there were repeated ongoing problems with the HVAC. You heard testimony from Rick and Denise about employees complaining and having to leave, them talking about and trying to describe how hot it was. I mean, they're describing to you, and the testimony is really unrefuted, that it was so hot that the refrigerator stopped working and that mold started to grow in the refrigerator. And when they tried to address that with the landlord seemed to kind of understand, well, it's impossible that created mold. When the obvious answer was, she's never saying that the heat created the mold. She's saying that the food in the refrigerator created the mold. There's still a mold issue, but it just goes to show this disconnect, how repeatedly, whenever the landlord's considering anything, they're kind of always diverting to the easiest, cheapest option. I guess that's the job of a landlord to do that to some extent. You know, they're not just supposed to throw out waste money, but at some point they are supposed to address and maintain the property and the concerns for their tenants. It's undisputed that the bathroom also had leaks. It's undisputed that the bathroom had puddles of water on the floor. It's undisputed that Rick fell and was hurt on November 12th of 2018 in the bathroom. It's undisputed that TMS also moved out of this building because of the problems. You heard Rick testify primarily about the relationship between he and TMS and the desire to start a property management business. That's the whole purpose for why they signed the amended lease. That's why the amended lease and TMS's lease are dated at the same time. That's why Rick and not Rick and lease individually, but HYH signed a guarantee. And this is, again, one of these points where I'm showing you, you'll see this constant leading of trying to persuade you to get to their story. They presented the testimony as if they signed personal guarantees. It's our argument that was not accidental. They know the difference between personal guarantees and corporate guarantees. He's a leasing agent, or I'm sorry, he's a leasing manager for at least 13 years. He's an experienced counsel, yet they told you these were personal guarantees. And the documents that we go back with you clearly do not say that. Credibility of witnesses. Here on behalf of the landlord is Kent Walker. I will agree with you. I've deposed Kent several times. He's a likable guy. He's a pleasant guy. He's a personable guy. But he has a boss. And that boss is his landlord. Think about his testimony regarding the bathroom leaks. We had put up an exhibit showing a bathroom leak photo from the ceiling with the fire alarm. And the photo clearly shows the water dripping down the wall. And then obviously you see the photos of the water puddling on the floor. But for them to have to admit or acknowledge that that might be a roof leak, that would be really bad for today. That would be really bad for these last 3 days. They definitely don't want to say roof leak. It's like roof leak is definitely not the word they want to come out of their mouth with regards to the bathroom. So what can Kent possibly come up with? He comes up with a theory, well, it must have been a plumbing leak. Okay, let's run with that theory. You saw Rick's email that day when he fell. He wrote back and said, hey, this has happened 3 times. And I've noticed that you've repainted the ceiling. And there's also the second photo showing that the ceiling has damage in it that's not by this alleged hatch. And the theory, if this was the plumber, well, where's the bill? Where's the invoice from the plumber coming out to fix this problem? They took the time to search all their records because we heard Kent testify about, I didn't have really time to search all this. This is a case that they're asking my client to pay at least $250,000 plus possibly punitive damages on top of it. But they're asking to pay $250,000, yet they took the time to find a $100 invoice for the carpet cleaning, but not to find any type of evidence to support this convenient theory. Well, I'm guessing it's probably, or it might have been a plumbing leak. And if the problem is we said credibility was important. So if Mr. Walker is willing to kind of try to bend and twist and work around the facts and saying, I cannot let this be a roof leak, my boss is going to kill me. If he's not willing to be honest about that, then how can we really believe him about his other testimony? Look at his testimony. Look at Mr. Walker's testimony with regards to Rick and Denise in terms of their question about asking for alternative space. So they've had this problem for a number of years, starting back in 2015. They have a reoccurrence of the same types of problems in 2018. They write and they say, we want to have alternative space. Their theory is my client is just trying to get out of their lease, and they're planning years in advance of how they're going to get out of this lease, knowing that there's going to be repeated roof leaks. But when they asked about the alternative space, we've got a direct conflict in the testimony between Rick and Denise and Mr. Walker. Mr. Walker says, we offered them equivalent space at the same price or similar, very similar price, nominal difference. Rick and Denise have testified, no, the reason why we turned it down was the one space was too small and the second space they offered us was too expensive. Does this fit with, again, Mr. Walker thinking, my boss is the landlord, If I say that that we didn't offer them equivalent space at the same price, it's gonna look really bad. I'll tell you guys, I'm taking my time because I'm nervous. I'm nervous because this is $250,000 at a minimum that they're asking my client to pay, plus punitive damages that could be substantially larger than that. So it's and if it's nerve-wracking for me, I can only imagine how nerve-wracking it is for my clients to have to sit there through this. The other question we have is Joseph Martinez, the point person, the guy that I was just telling you about, turns around and walks away when you try to discuss with him problems with the building. Were Rick and Denise wrong for complaining about, hey, my roof is leaking, my ceiling tiles are falling, my carpets are soaked, we've got buckets in the hallway, we've got fans blowing everywhere? Were they wrong, or is that somehow inappropriate to try to talk to Mr. Martinez about that? And I don't know, maybe Mr. Martinez was frustrated because he was trying to get the landlord to fix it and he couldn't get the landlord to fix it. We don't know that. Why don't we know that? Because Mr. Martinez never came to court. Mr. Martinez was their employee. Mr. Martinez was the person that had the most contact with Rick and Denise regarding these problems. He would have been great for all of you to be able to hear, to judge his demeanor, to hear his response for when Rick and Denise said, we couldn't talk to the guy. He was like very adversarial to us. He turned around and he walked away. He called us you people. Well, where is he? The court is going to give you a jury instruction that you are allowed to consider that if a person is missing, if a witness is missing, and that witness may offer testimony that helps or hurts one side or the other, you're allowed to consider the fact as to whether or not there's a reason why that person may not have been brought into court. And I'm asking you to consider that fact. Wouldn't he have supported their case? If what they're saying or what they're telling you is true, wouldn't he have come in and wouldn't they have spent the time rather than digging up the $100 carpet cleaning receipt to bring Mr. Martinez to court? I mean, they have all that even if he's not currently working with them, they know his last address. They have more information about him than we certainly do. The crux of my client's what's called an affirmative defense, for which they have the burden to prove. Obviously, the landlord has the burden to prove an initial breach of the lease. They're going to say, obviously, they didn't pay rent. They're going to say they had unauthorized tenants. I'm just going to touch on the unauthorized tenants because you all can read the lease with your own eyes. It says quite clearly you can use it for an insurance agency or tax purposes. I'll leave it at that. But in terms of the constructive eviction, Rick and Denise testified that they needed the reason why they rented their space, it's pretty obvious. It's a common business reason. They needed it to meet with clients. They needed to have computer space desks for their staff to work at. They needed to have a place to store files. They needed to have a place where they could have confidential communications with their clients. These are common purposes for a business, but they are also essential purposes for the business. They were not able to do any of these things. I mean, this problem's directly interfered with each and every one of those basic things they needed to do. It also interfered with the whole issue of TMS, because if TMS was moving into the property in order to start this property management business, well, that soured and destroyed that relationship. So the tenant's failure to maintain, the landlord's failure to maintain the building and the landlord's failure to stop the leaks, the HVAC, the smell, all these things, if that drove TMS out, and that's exactly what we're saying, they actually moved out a lot. They didn't have the patience that Rick and Denise had. They left. And that destroyed the whole purpose for why they renewed, the whole purpose for why, yes, they did sign guarantees. They signed corporate guarantees, but they signed guarantees. And that's my evidence to show you that why that relationship was so important. And that was destroyed. And that cannot be replaced. Yes, he could start another property management business, but he was merging with them for a reason. He's not going to start a property management with the partners that he chose and that he wanted to select. So for constructive eviction, you're going to be provided case law and instruction from the court that's going to say that you need to have two elements. The first element, I think, is fairly straightforward and easy. Landlord's failure to keep the building repaired allowed it to deteriorate to such an extent that it had become an unfit place for Rick and Denise to carry on the business for which it was rented. We talked about for why it was rented, and I think quite clearly these problems interfere with that. The second part of the test or the elements is it could not be restored to a fit condition by ordinary repairs, which could be made without unreasonable interruption for Rick and Denise's business. This is kind of where there's a little bit more. In order to try to clarify that, the courts have also added this language, says, put another way, to constitute an eviction which will operate as a suspension of rent, there must be some act of grave and permanent character done by the landlord with the intention of depriving the tenant of the enjoyment of the demised premises. So the court was trying to clear this up, but I'm thinking they may not have actually ended up clearing it up. But the question for us is this grave? It does say actually an act may be construed grave in character if it renders the premises untenable or unfit for the use and benefit of the tenant in accomplishing one or more of the substantial purposes of the lease. So I think the grave aspect is fairly clear that this is a problem that anybody would be complaining about. The question of what you're going to hear probably a lot of argument from Mr. Merritt is this element of permanency and what does that mean? And our position is that you need to read and interpret that word permanent as in context of the whole two paragraphs. Because the idea here of constructive eviction boils down to really a failure of consideration. The landlord's supposed to provide a usable space. The tenant's supposed to provide rent. Landlord's consideration is the space. Tenant's consideration is the rent payment. They failed to provide the consideration. They never provided usable space. The whole language of the permanency issue is we're not supposed to be talking about some short-term problem. We're not supposed to be talking about something that can be easily fixed. That's why they have the language an ordinary repair. So an ordinary repair would be a roof patch. An ordinary repair would not be a replacement of a roof. That's replacing an entire roof structure. The other thing is, what are we really talking about in terms of repair? Repair is one piece of it is the roof. You got to plug the leak. Then you got to monitor whether the leak stopped. And then once you monitor whether the leak stopped, you take down all the tiles. You have to determine, do we have a water moisture problem? The same thing that the landlord was worried about in their paid paragraph 8 of their lease. Okay, do we have a moisture issue? Did the landlord come in and do any moisture tests? No, we didn't hear anything about it. Did the tenants report, I smell mildewy, musty, wet odors? You can walk on my carpet and it squishes. I mean, what more do you need to be able to say, okay, there could be an issue with mold, maybe we need to do some testing. You also get into whether or not you should be replacing drywall. There's another photograph of the hallway where it's got the multiple buckets, it's got the big blower going, and you can see, when you go back to the jury room, you'll have all the exhibits with you, and you'll be able to see the water dripping straight down the wall in the hallway. None of that was replaced. They did, again, the cheapest, easiest fix for the landlord. They patched the roof. And of course, what happened to the intervening events between these things? We had the intervening events of Rick falling. At what point in time is enough enough? I mean, how many falls is a landlord asking Rick to be able to take? How many clients are supposed to be at risk just using the bathroom? Or the employees? How many ceiling tiles need to fall on your head before the landlord is going to say, okay, we've got a pretty substantial problem here? Could this not have all been solved if the landlord would have maybe just replaced the roof after 3 attempts to patch or after 4 attempts to patch? This is a problem because the landlord didn't replace the roof until after a pivotal event and after a point where it's saying, this is just not even safe for us to use it anymore. I mean, it's ridiculous to think that he's sitting in a bakery across the street from the office space that he rented to be able to work out of. And they have the goal to be asking you guys to award punitive damages to them against us. The other, the other, the other thing that just kind of strikes my mind in this case is they're asking them to pay for the replacement of the carpet that was wet in the unit. So clearly it needed to be replaced. They're willing to do it for the new tenant, but part of their calculation of damages is the cost to replace the carpet. So the carpet that they ruined from the lack of repair from their building because they bought it in foreclosure and probably didn't have a lot of information about the building and didn't spend the time to inspect the roof. They waited for the roof to leak, and they chose to be reactionary rather than proactive. Voidable transfers. Because Rick and Denise didn't sign personal guarantees, in order to try to go past HYH Corporation and to try to go after them individually, because the landlord was not upset about Rick suing them for slipping and falling in the bathroom. For that reason, they've tried this theory, or they're going to propose this theory to you about what's called avoidable transfer, to say that when Rick sold his book of insurance business in 2018, in May of 2018, that was part of their grand scheme of saying, let's take all the assets out of HYH because we want to breach the lease with the landlord, and that way they won't have anything to go after. The problem with that theory is, if anyone's ever sold a business, it doesn't happen overnight. You have to make the decision to sell the business. You have to then find a buyer to buy the business. Then you have to deal with lawyers to some extent to draw up the contracts to sell the business. And in order for this voidable transfer to be applicable to hold the defendants personally liable, they also are going to need to establish an intent to defraud or to hinder or to delay the landlord. My clients have testified and have asserted to you that they believed that they do not owe the landlord. They believe that they hired lawyers to send letters to give them options to say, look, we have these problems. We're putting you again on official notice. We can't take it anymore. We want either alternative space or we want to vacate the property. This was not done in terms of trying to hide or transfer assets. Same argument with the piercing the corporate veil. The whole purpose of that is somehow to try to go after the defendants individually to say, oh, you guys must have commingled assets. You guys must have mixed things up. Therefore, we should ignore the fact that you have an LLC and we should be able to go after you and do it. So we spent how much time hearing about a Nordstrom charge for $42 and an Old Navy charge, which quite frankly, that statement doesn't show what it was used for. Denise testified quite clearly that these cards could have been used anywhere. And I don't remember exactly where they were used, but I could have bought it at Staples. I don't know. And the other thing that's crazy is, of course, they have multiple businesses. Are they really expected to go to Costco on Monday? They put on their HYH hat and say, I'm shopping for Costco on Monday. I put that in my HYH section of storage at home because they can't use their office. Or they go to HYH, then on Thursday, they go to Costco for HYH2. And if there's any other businesses, they go on Friday for that business. And they keep these all in separate compartments in their home because they can't use their office in order to keep things separate. Denise testified that she keeps meticulous records. Those are the QuickBook records. Again, not here. No issues of discovery happens before a trial. If stuff was missing that the plaintiff wanted, they have a large law firm. We have the plaintiff that they've told us they spent $160,000 on this case. But I guess they forgot to ask for the QuickBooks, just like they forgot to ask for that plumbing receipt. So they spent all this time going through trying to say how they commingle all these assets. But Denise testified quite clearly, I've kept separate records. I have separate bank accounts for every entity, and I file separate tax returns. We keep these businesses separated. The alter ego theory that they've also asked for and pled is the same type of analogy of piercing the corporate veil. It's saying that they treated these entities so similar that you can't decide which one is which. And this purpose that they're trying to use the piercing the corporate veil formed for is not really what it's designed for. It's designed when people create a corporation to try to trick you. So they create a corporation, like think of a contractor coming to your home and they say, I'm Super House Builder Incorporated, but they're really just Bob. And they hand you all the paperwork and it says the name of the corporation, but when you write out the check, you say, just make it out to Bob. Because then Bob puts it in his own account. The whole time you're thinking I'm dealing with a larger corporation and they're kind of tricking you in terms of not knowing who you're really contracting with. Was there ever any confusion on the part of the landlord as to who they were contracting with? Did they not understand that they were contracting with HYH? HYH had two purposes at the time they signed their lease: insurance and taxes, and Rick and Denise were the owners of those businesses. There's no confusion. The whole purpose of that allegation is to be able to go after them individually. And quite frankly, it seems as though the landlord is pissed about that lawsuit. Because if you heard Mr. Walker, there's a couple of times where I think he slipped up and got a little bit testy up there, even though he's a very personal guy. When the one time when he was asked about the repairs, he slipped in a little snide comment about, but it was never enough. That kind of, I would think that would rub almost anybody the wrong way. Never enough. Never enough. How many years, how many falls, how many ceiling tiles? But according to him, they're just never satisfied. And also the timing. We talked about the settlement. Mr. Walker, I was saying about him getting a little bit agitated. He kind of blurted out in the stand, Rick and Denise got $270,000. Why? Because they heard in all the jury instructions or the voir dire process that people have a general belief that oftentimes injuries are exaggerated. Now, you're not here obviously to decide his injury. That case is resolved. But he wanted you to hear 270. Well, coincidentally, when Mr. Merrick gets up here, they're going to show you probably damages for just close to $270,000. And also the timing. The settlement for Mr. Hahn's case happened in March of 2019. The big demand letter that came out from the landlord, they did nothing for over 12, 14 months. Then the month after they settled the case, they get, boom, you owe us all this back rent for $100,000. But it has nothing to do with it. That didn't influence them at all. The last thing I will argue to you is the issue of damages. So when you have a contract with somebody, you're supposed to be able to, the damages are supposed to put them back in the position they were in because of the contract. And you're not supposed to try to mix tort damages like all these car accident cases everybody's saying is too much money for, because those kind of go up and up and up. With the contract case, it's usually pretty clear and pretty straightforward that this is the breach of the contract, this was the amount of your lease, this is the amount that you owe. But with a tort case, you're getting into all these other issues like punitive damages. Hey, we think you should punish Rick and Denise Hahn because of their elaborate scheme and that they were defrauders and they were planning since 2015 to sell the business. My insurance agency is going well, but I'm going to sell it because I'm going to have a roof leak again, I think, and I really want to get out of this space. The punitive damages are all about exactly how they've treated Mr. and Mrs. Hahn the entire way through this process, is basically ignoring them, minimizing their problems, and then on top of it, it's just like I said with the carpet. They're going to take the time to say, I want you to pay for the carpet that we ruined and that we're going to sue you over. I'm asking you for a finding that the landlord breached this lease when they failed to repair the roof and keep the building in maintenance. I'm asking you to find that that was a substantial problem that interfered with the essential purposes of why they rented the space to begin with. I don't think this case is that complicated. I don't think this case really required coming to a trial. I don't think this case really required 4 days, but here we are. And I'll remind you one thing. They're the plaintiff. We are the defendants. They sued us. We are all here because of that reason, because they brought us here with their claim. Their claim, which comes down to the issue of them literally having the gall to sue them over complaining about the condition of the building with ceiling tiles falling on your head for years. Thank you very much for all of your time. I appreciate your attention.
You guys could bear with me 1 second. I don't know why, but this happened. This has happened twice now. When I plug it into the video cable, my laptop just restarts the second it plugs in. It only takes just a couple of seconds. Um, All right, here we are. All right. Sorry about that. I've never had a good relationship with technology, and today is obviously no exception. I wanted to thank you guys one more time. I've had the privilege of doing quite a few jury trials. I know nobody wants to be here for this. Nobody's wanted to be here for this. And that is, you're not special. I don't think I've ever tried a case where somebody was just nerding out over their civic responsibility. They were just thrilled to be there, hoping they got picked. I am, actually. This is literally what I wanted to do since I was a little kid. And Miguel's probably the same way, Mr. Devon. I mean, I literally went to law school and incurred more debt than I would ever pay off in my lifetime so that I would have the opportunity to do things just like this and represent clients like American Capital Properties. But I wanted to thank you for two things. Number one, I wanted to thank you again just for serving. And number two, for not falling asleep, for paying attention. This is admittedly one of the driest cases I've tried. I understand how difficult it must be to try to force yourself to pay attention while two attorneys talk about lease terms for 3 or 4 days. I get it. And I do appreciate it because regardless of how boring the subject matter is, it is incredibly important to not just my client, but to Mr. and Mrs. Hahn. So on behalf of both tables, I think I can speak for both to say thank you for not only doing this, but for paying attention. I'm going to start out just by talking a little bit about the maintenance issues, because obviously that's a huge part of this case. Mr. Devon said that my client was going to try to paint Mrs. Hahn like a Karen. And, it's a funny reference. I don't believe that that's really what my client has done at all. And to the extent that that might be seen by some of you, I think on the other side, it looks like that the defendants are trying to paint a nice Atlanta office building, which, and by the way, even yesterday, Ms. Hahn, when she was testifying, she said it's a nice building. And it is a nice building. I've been in this building. And they would like for you to think that somehow they have maintained tenants and stayed profitable, and they continue to operate this building despite the fact that apparently every day for 7 years, when you walk in, this place looks like Kevin Costner in Waterworld, and that's just not the case. I know that there are a couple of photos that on their own look bad. I get it. My client has never denied that there were roof leaks that needed to be fixed. And nor did my client deny that they didn't know about these when they acquired this building in 2016. I mean, you guys are going to take the evidence back with you into the deliberations room. You'll get to see every piece of paper that we've been talking about this trial. And you'll see the same thing that I see, that the majority of these complaints, there were a few in 2015, but the majority of these were from 2018. The vast majority. And any of you who are familiar with, leasing or renting property probably know that if there's a roof leak, your first step is not to put a $200,000 roof on. Your first step is to call a roofer and see if you can patch the problem and fix it. And every time that happened, it was addressed. But, as my client said, they were getting frustrated. I mean, again, for those of you that have rental properties, you know, as well as my client knows, when you have unhappy tenants and you have roof leaks in a property that you own, that's not good for business. It doesn't help my client for water to be coming in from the roof. That every time a roofer comes out, it costs them money. Roofers don't work for free. That's more money my client had to pay. And, you know, you heard my client testify that just because something is cheap doesn't mean it's best. In fact, if it was, they would have kept the old roofer. But they went out and found a better roofer, a new roofer to replace the entire roof on the whole building. And there's zero evidence that even a drop came through that new roof after it was replaced. Defendants don't know that because they were moving out. Something else you'll see. All of these communications are going to go back to all these emails. And I want you to look at them because you'll see the same thing I did. What you're going to see, one of the things you're going to see is a landlord that is always responsive. Always. Not only always responsive, always promptly responsive. The only thing I've ever rented was a townhome when I got married and for a little while, and a one-bedroom apartment that I had until my first son was born. And me and my wife and my son lived in this little one-bedroom apartment for a couple of months till the lease ran out. It was rough, but I appreciated when my landlord would at least be responsive and try to address things when I would bring them up. And that's exactly what the tenants of the Crescent Building, including Mr. and Mrs. Hahn, got when American Capital Properties took over this building. And you'll see that in these emails. You'll also see that, consistent action, consistent. Now, I understand that Mr. and Mrs. Hahn claimed that they were never fully satisfied with the things that were done. The point I'm trying to make is things were always done, always. Those emails show action. Every one of those emails, look through them. Our roofer's coming out tomorrow morning. Our contractor's coming back tomorrow night. Our janitorial team is coming in after you leave at 5 p.m. tomorrow to shampoo and steam clean your carpets. Our maintenance team is going to be moving all of your furniture out while the carpets are steam cleaned and moving your furniture back in once that's done. You know, we when the noise complaints were made, we went in and listened, and they couldn't replicate it. And it was not out of the ordinary for a commercial office. You heard that there was some like mumbling a little bit through the walls. I've worked in many offices. I know that that's not out of the ordinary. And you guys don't know this, but one thing that's important that I'll just mention under Georgia law, and this is true in most states, when you sign a commercial lease, there is usually a provision that says you accept those premises in as-is condition. That means you've had a chance to inspect them. And that includes noise levels. Like if it's not suitable for your business, you shouldn't sign that. Because when you sign that, you're agreeing that we accept it in this condition. All right, now nothing changed in these walls. They didn't become thinner over time. The noise levels would have been the same. And what hasn't really been discussed a whole lot is not only these tenants moved in 2012, they stayed there for almost 7 years and extended their lease at their request. That whole time, the walls, the ceilings, nothing changed. Nothing changed. So why is it that the noise complaints didn't start until years later? The walls didn't get thinner. And I would suggest, and I think the evidence implies, that there is a story behind the story. It's a curious timeline. As you go back to deliberate, the first thing that you'll probably do, the first thing I think you should do is select a foreperson. And after that, you're going to start looking at the evidence and begin your deliberations. As you look through the evidence, I want all of you to discuss and ask yourselves one question. Did this tenant move out because of this narrative, or was this narrative created so they could move out? Okay? Because to me, the timeline is kind of curious. When the majority of these complaints came in, 3 things were simultaneously happening, and maybe they were just coincidence. Number one, the company in the adjacent suite that they had personally guaranteed the lease of was struggling financially and could not afford to pay their bills. Number 2, they had already secretly sold their entire business that they were supposed to be operating out of this space and never bothered to tell the landlord that the tenant was no longer serving their clients. And number 3, They were already forming a new company and looking to buy a new office building so they could lease office space from themselves at a sweetheart rate and operate all of their family of companies out of their own building and pay themselves the rent. Those three things happened at the same time that, curiously, all of these maintenance issues started. Now, again, we're not saying and have never said that the roof didn't leak a couple of times pretty seriously, or that water wasn't coming into the bathroom on at least one occasion. We never have ever disputed that a couple of times when water came in, the ceiling tiles stained, and a few of these ceiling tiles did fall. And we're not saying that the carpets got wet a couple of times, because you guys saw, we addressed that too. We brought in blowers. That's how we steam clean the carpets. But the third thing that you're going to see as you go through these communications is that all of these issues were addressed. All right. Consistent, prompt communication and responsiveness, consistent action, and consistent resolution. Okay. At the very end, when they're already making plans to move out and move into their own office building, my clients, and you'll see these emails, they're going back with you. My clients are reaching back out to them, listing all of the things they've done and saying, could you be specific? What maintenance issues remain? Could you be specific? You know what you're not going to find? Response. There was no specific response because those issues have been addressed. There was no complaints of water because just a month earlier, at the first week of December, that brand new roof was put on. The HVAC unit, there was a time when the temperatures did get a little bit uncomfortable. And fixes were made to that too. In fact, the entire chiller unit, the power unit that powered this AC unit for this entire building was replaced because they just wanted it done, not just done, but done correctly. None of that was cheap. All right. The first thing you're going to look at is the lease. So what are some of the key lease terms? Well, number one, I've already told you, 2.02, HYH accepted these premises in as-is condition. Importantly, they did this not once, but twice. You'll see down below section 4 of the extension of the lease, they did it again. They said, hey, once again, we've looked around, we've inspected, and we're satisfied with the condition of these premises. Now, that doesn't include water leaks. Water leaks aren't present. Nobody's going to say, yeah, we accept the leaks. That's cool. But that does include noise levels. I mean, they would have known what the noise levels were. They had been in the office for 3 years at that time. And that's part of the as-is condition under Georgia law, noise levels, the walls, the ceilings, the thickness, all of that. Section 3. If you don't pay your rent, you get a 10% late fee, and unpaid rent incurs interest. That's really not that out of the ordinary for a commercial lease. In fact, I've seen a lot worse provisions for that. Number 6, and this is important. Number 6, they agreed when they signed this lease. And by the way, this is also pretty common in commercial leases. There's a lot of different things that happen in commercial leases when you're dealing with companies rather than just people renting an apartment or a house or townhome. You're dealing with sophisticated parties, companies, people with lawyers. So number 3, they agreed that yes, the landlord has an obligation to furnish water, HVAC, basic services for the building, but any failure of equipment or any interruption of those services, even if it results in property damage, not only would not be considered a constructive eviction, but would not excuse the full payment of rent. And at this time, I want to point out something, because it's kind of been implied or inferred that what were they to do? What were they to do? I mean, water's leaking, you're supposed to just bend over and take it? No, that's not the case. Georgia law gives even commercial tenants a remedy if you're unsatisfied with the landlord's actions to maintain the premises and make repairs. But Georgia law is also clear that that action, that remedy, is not constructive eviction in a case like this. Now, the remedy under Georgia law is you can sue your landlord for diminution of rental value. That's what that claim is called. It's basically like an abatement of rent. It's basically saying, yeah, we have access to our office and no one's stopping us from going in, but the carpet's wet or there's water coming in. So this isn't worth $2,800 a month right now because we can't do the kind of business we normally do. Well, Georgia law said, yeah, Georgia law agrees with you. You can sue your landlord for what's called diminution of rental value. They could have asserted a counterclaim against my client, but they didn't. They didn't avail themselves of that remedy. There's another remedy Georgia law gives you, by the way. And most of you that have rented may or may not know this. The remedy is called self-help. So Georgia law says, if you don't want to sue your landlord for diminution of rental value, but you also don't want to bend over and take it, you still have a remedy. If the carpet's wet, you get the carpet replaced or cleaned yourself and deduct your rent. Repair it yourself and deduct the cost from your rent. And so under Georgia law, what a tenant can do, and this is true, by the way, even if you rent an apartment, if your landlord doesn't timely, in a commercially reasonable manner, make a repair after being provided notice, Georgia law says you can take matters into your own hands, get that thing fixed, whether it's the heating and air conditioner, the roof leak, whatever. You can get that, you can fix it yourself, deduct the amount from your next rent payment. And when your next rent payment is due, you make a partial payment. And for the remainder of the payment that you credit yourself, you give the documentation like receipts and invoices to your landlord in lieu of the rent payment. They didn't do that either. So number 6, shall not constitute a constructive eviction. That's a quote, by the way. And that's important because if you really consider the entire body of evidence that's been admitted in this case, one thing I think that, one conclusion I believe you can come to is Mr. and Mrs. Hahn love to rely on parts of the lease that they like. And the parts that they don't like, they treat it kind of like a buffet line. I want a little bit of HYH2 is not on the lease, so we're not responsible to pay you any of the unpaid rent because we don't have a contract with you. They want a little bit of that. They want a little bit of the landlord told us that it's obligated to make repairs and you didn't do it to our liking. We want a little bit of that as well, but we'll have none of this. We have to pay late fees and the interest. No, we don't really want that. And this whole part about shall not constitute a constructive eviction, we'll pass on that part. And they like to cherry pick what parts of the lease they want to enforce and what parts they don't. Now, I think it's important to point out that they only do that when they're obligated under the contract. When it's their contract, that's when they kind of cherry pick. They're like a little bit of that, but we don't want any of this part. When it's a contract where they're in my client's shoes, it's not the same. I mean, you heard Mr. Hahn, he sold his business for $500,000. $450,000 was paid in one lump sum upfront, direct to them cash. The other $50,000, the buyer, GIA, Gwinnett Insurance Associates, signed a promissory note to pay. But what happened? They defaulted on it. Well, Mr. Hahn sued him. He sued him in court. Why? Because they broke their contractual promise to pay him the money he's owed. So he had no problem using the justice system to get the money that he was entitled to. He just doesn't like it when my client plays by those same rules. When he slipped and fell, he had no problem suing my client, hiring lawyers and going to court to get $275,000 that he thought he was entitled to. But then he wants to drag my client's name through the mud because we're doing the exact same thing. This is why courts exist, to enforce promises that people break after they sign a contract. So the contract also says that and by the way, again, a lot of this stuff is boilerplate. It's common. If you ever rent an office space, 90% of the leases I've seen have similar provisions to this. One of those provisions, there's a lot of complaining in this case about, well, water got on our furniture and, we didn't get an abatement of rent because our table, we had water that hit the table or, some of the furniture had water on it, was damaged. Yeah. If every time anything that a tenant had got damaged, the landlord had to pay for it, it would be chaos when you have hundreds of tenants in big buildings or high rises or skyscrapers. Commercial leases almost always provide that if you're going to rent space here, it's your obligation to acquire insurance that no matter what happens, even if there is a roof leak, if your property gets damaged, you need to have coverage for that. And they did, or they were supposed to, but they didn't go through insurance. They just went to my client to pay for it. My client said, well, you're supposed to have insurance. That's something you're supposed to do, but that wasn't good enough for them either. That's my client's fault, even though they already signed a contract stating that they would rely on insurance to cover that. But somehow my client's the bad guy because my client wanted to enforce that provision as well. That was another one of the provisions they wanted to leave. They didn't like that part. The contract provides that if either party files suit, the winner is entitled to fees. It provides events of default. Any one of those events is a breach, material breach. The 2015 extension of the lease, again, accepted it as a condition. Once again, section 12, they agreed once again that they would not bring any claims against the landlord and agreed that landlord wouldn't be liable for property damage specifically caused by roof leaks and leaking pipes. They agreed to that. And then finally, as we've discussed, it was their request that the landlord paid for the construction of this new wall and a big glass door because they wanted this to look nice and shiny for their clients. That's what Mr. Hahn said. We look prestigious, something like that. We wanted that. We wanted this appearance for our clients to come in. We wanted this grand entrance. Well, the landlord paid for that. Didn't charge them a penny for that. But in exchange, the landlord said, yeah, we'll let your friends that you're doing business with, trying to get into this other property management, we'll let your friends move into the next door suite. We'll pay for the glass door. We'll put all that stuff in. But we're only going to do it if you guys guarantee their lease as well, because that's even more liability for us. So we'll do it, but you got to promise that if they don't pay, you will. So that was included. So those two leases are, in legal terms, they're called cross defaulted. This means a default on one is automatically a default on the other. Even if you didn't default on yours, if they do, you do. Right, so what are American Capital Properties' claims in this case? Obviously, the first one is breach of the lease. Now, under the terms of the lease, there were multiple breaches. All right, and there's one breach that I don't think anyone should disagree with, and that is if you have a company and you sign a commercial lease and you agree to continue operating your business and your business only out of that office space, you are not allowed to sell your business and stop operating it and liquidate the bank accounts and dissolve with the Secretary of State in the middle of the lease without mentioning any of that to your landlord. That is just, I mean, I shouldn't even have to say that, but apparently in this case I have to. So that happened. That happened in May of 2018. They failed to make rent payments. Is number one. They stopped operating as business. HYH Consulting. They sold their book of business to GIA. Number three, they abandoned the premises before the lease term. Can't do that. That's a big no-no. Number four, they became insolvent. They became unable to pay their debts, and not like they just went broke, because they didn't. They became insolvent by selling the business and then draining and closing the account. That makes any company insolvent. And then they actually defaulted, and this is just a weird technical legal argument, but it still is true, so I listed it. They also defaulted by 4 different defaults on the TMS lease, because TMS became insolvent. TMS failed to make their rent payments. And well, I put insolvent there twice, that's my fault. And TMS abandoned its premises. Well, in fact, TMS had already moved out. Now, they would like for you to believe that TMS hated this property because of these maintenance issues. And it's clear, it's undisputed that that's why they moved out. Really, there's only one piece of documented evidence that explains anything about why TMS moved out. And that was an email from Ms. Hahn to my client saying, could you guys please look for a replacement tenant? Business is slow and they can't pay their bill. That's the only evidence we have of that. So the lease, I would argue, my client has met its burden of proof that the lease was breached. Now, the second one, Georgia used to, most states have it. It's actually what's called a uniform law. And Georgia has its version. It used to be called the Fraudulent Conveyance Act. Recently, it was the name of it was changed, but it basically still says most of the same things. Now it's called the Voidable Transfer Act, and this is a statutory. In fact, it's so important The Georgia General Assembly has codified this and made it Georgia law. So this is not something that was created by the courts. This was created by the state legislature. And this is the case, by the way, in almost every one of the 50 states. And what it says is if you owe money to a creditor, and that doesn't have to be like a bank or a lender, it can be a landlord, it can be anybody, any creditor, any account that you have open, it can be a credit card. If you owe money to a creditor and you transfer any assets or money out of your business, and because of that transfer, it renders your business insolvent. That is like a variation of fraud, and the law does not allow that. The law allows damages for that, okay? Because the law views that as a type of dishonesty. So of course, the facts of this case, I believe, fit the exact definition of the statute, so we included that claim as well. Now, other than punitive damages, we're not asking for double damages. I'm not asking to pay us for all these different claims. You know, Mr. Devon thinks there's some kind of coincidence that, you know, are the damages we're going to claim is going to be like, you know, suspiciously around the same amount that Mr. Hahn got from the personal injury suit, but that there's literally no basis for any of you guys to believe a word of that, because the damages that we're asking for aside from punitive damages can be calculated from the contracts or in the lease letter. Whatever coincidence there might be that they're anywhere close to each other, you know, and you also heard my client say that the settlement money, the slip and fall didn't even come out of my client's money. It was paid for by insurance, as was their lawyers in that case. So my clients didn't have to pay for that. That being said, I mean, Mr. Hahn was fairly compensated for that. Yeah, he did slip and fall, and he got over $250,000 in exchange for it. So we're not asking for additional damages outside of punitive damages. We're asking for just what we're entitled to under the lease itself. All right, this is the second type of fraudulent transfer. I'm not going to go over it, but there's two statutes that outline two different ways that a transfer can be deemed as voidable or fraudulent. And actually both of those are satisfied. Now, I just want to reiterate to you guys that, and the judge has already said this, but anything that is said by Mr. Devon or I is not evidence. This is just our summary of the case, our summary of the evidence. But whatever Mr. Bond just said, whatever I'm just saying right now, this is not evidence. And we can tell you certain things that are legal principles, but your job is to do two things. Your job is to find what you believe the facts to be based on the evidence. That's your first job. And your second job is, once you determine what you think the facts are based on the evidence and testimony, your next job is to apply the law as the judge is going to explain it to you. He's going to read jury charges, and those jury charges summarize what the law is. And your second job is to apply the law as the judge instructs to the facts as you find them. Oh, let me go back to this. So breach of fiduciary duty. Now, normally the owners of a company do not owe a fiduciary duty to creditors of the company. Typically, that's not the case. This is not like, you know, a fiduciary duty that you have like with a financial advisor or, you know, sometimes a lender has a fiduciary duty. Normally, you know, if you own your own company and that company takes out a loan or a line of credit, you as the individual owner of the company owe no fiduciary duty to the creditor, to the lender. But Georgia law says there's a way that you can. A fiduciary duty can be created. And what that means, when that happens is and this is true for limited liability companies like HYH, just like any other company, when the owners of the company allow the company to become insolvent, whether it is just from going out of business or selling its assets and cleaning out the account. When you allow your company to become insolvent, if you have any creditors, then you have now at the same time created and breached a fiduciary duty. Because once your company starts going out of business or once you start selling off assets of your company and draining accounts, if that renders your company unable to continue paying your creditor, you, as the owner, you've breached your fiduciary duty to the creditor. So similar to the Voidable Transactions Act, we're not asking for a second item of damages for this. It is a second claim, and it's important, and I'll explain why in just a moment. But it is a viable claim in this case, because under the facts of this case, the fiduciary duty was created and it was breached by Mr. and Mrs. Hahn. Mr. and Mrs. Hahn have said that their business was like suffering because of this. They couldn't meet with clients, couldn't do anything. And it wasn't just them, it was TMS. That's why TMS was going broke. That's what they told you. The TMS wasn't just the business was slow. It was slow because of American Capital Properties, because the ceiling tile or two fell on the floor and the carpet got wet a couple of times. That drove TMS out of business. That's what they want you to believe. But when I asked, well, why didn't it drive HYH Consulting out of business? In fact, HYH Consulting was doing great. I don't know if you guys remember it, but I wrote this down. Mr. Hahn actually told you this yesterday. He testified. You know why we asked for an alternative office space? Because you want to work something out when you're doing well, and we were doing well. That's what he said. And they were doing well. That's why someone wanted to pay $500,000 for their book of business, because they were doing great. And they were doing great even after being in this specific office suite for 7 years. They were doing great. Piercing the corporate veil. I want to get into this because this is kind of a complicated, it's not very complicated, but it's a legal doctrine. And basically it's similar to breach of fiduciary duty. In this type of fiduciary duty that we just talked about. Basically what it means is, and I'll take the time now to just explain to you guys, I know how monotonous it was. I actually could have gone on for 2 or 3 or 4 more days, but I know how boring it was to go through all those bank records. I get it. I didn't want to do it any more than you guys probably wanted to listen to it, but I had an obligation to lay an evidentiary foundation for this exact reason. There is a reason why, you heard Mr. DeBon, I wrote down in his opening statement, because there's an issue in this case about who is actually on the lease, who is actually liable, which one of these companies. Well, he says, Mr. DeBon says, it doesn't really matter which hat they're wearing, right? Like if you have a number of companies, it doesn't matter that only one of those companies is on the lease. Now, Mrs. Hahn thought it mattered when we sent a demand letter for unpaid rent to HYH1 and HYH2. She certainly thought it mattered because her response said, HYH2 is not on the lease. We don't know you anything. Leave us alone. She thought it mattered, even though she had been doing business in this suite with her clients. But it didn't matter until it was time to honor the rent obligations. It started mattering pretty quickly when that happened. And you'll see that. But here's the corporate veil. When the whole reason why, if any of you are business owners, you probably know this, or if any of you have consulted with attorneys or accountants, people will tell you, anybody that knows what they're talking about is going to tell you, you have to incorporate, protect yourself, right? You have to, it's important to incorporate, you have to protect yourself. And if you own more than one company, it's important to keep separate records. That's why Ms. Hahn testified, no, we always segregated, everything was kept separate, it was all proper. Why? Because if you don't do that, it's not proper. You can actually expose yourself to liability. And if you create a company to protect yourself, the law basically says if you want that protection, you have to stay separate from your company. You cannot disregard and ignore the corporate form. You can't just start using your company bank account like it's your own personal checking. You can't be paying your personal expenses with company money unless you document it, sign a promissory note or a loan agreement, or otherwise keep strict records, show what's coming in and out. But in general, it's really not a good practice. It's pretty reckless, but for this exact reason. And so if you, for example, and same goes for when you own multiple companies. You can't be exchanging employees, property, assets, money, making transfers. You can't be doing that between companies, because if you do, that's what alter ego means. You're just using one as the alter ego of the other. You're not really treating them as separate. And if you don't treat them as separate, the law isn't going to treat them as separate. If you don't treat yourself as separate and distinct from your company, the law isn't going to treat you as separate and distinct from your company. And this isn't Georgia, this is every state in the union. If you there's a series of factors that courts look at to determine whether or not that standard's met. The number one factor, if you want to find the quickest way any of you that own a business, if you want to find the quickest way to have a creditor hold you individually liable for your company business, start commingling funds. Start paying your personal expenses with your company account. Start lending your money company and don't forcing your company to pay it back, or putting money from one company into another so that the other company can cover a business expense. And don't keep good records, or don't repay it, or don't sign promissory notes, things like that. Just use it interchangeably. That's the quickest way to make that LLC at the end of your company name no longer matter for personal liability reasons. And suffice it to say, that happened here a lot, actually, on a pretty regular basis. I heard Mr. Devon say that Mrs. Hahn's testimony was clear. I mean, you guys heard the same testimony I heard. I mean, it was clear. It was clear about two things. Number one, all of those expenses were personal accounts. She was clear about that, right? Personal Home Depot, personal Nordstrom, personal Old Navy, personal car payment, personal checking account deposit, personal American Express. That's my personal American Express card. What were those for? Well, that's where the clarity ended. I don't know. I don't know why Wells Fargo would call that Old Navy. Well, that must be Wells Fargo's system or something. The clarity stopped after admitting that these were personal expenses. That's what I heard. Mr. Devon mentioned this. I mentioned at the beginning of this case as well, but I'll just go over this one more time. My clients bear the burden of proof on their claims. And I believe my clients have met their burden of proof. And so to meet your burden of proof, again, I don't want to make this a legal TED talk, but the law calls it your prima facie case. It just means you have established the minimum amount of elements to establish your claim. Well, we've done that. I mean, just talking about breach of lease, the lease says you make payments until the lease term, and even if the roof leaks, it doesn't excuse rent payments, and it doesn't constitute a constructive eviction. The lease is black and white. Nobody's argued, no one has argued that that lease is unenforceable. The judge is going to read the law to you guys in a second, and you know what you're not going to hear? You're not going to hear that this lease is unenforceable under Georgia law. He's not going to read that to you, because it is. So I've heard no explanation for why the lease shouldn't be complied with, including the provision that says if the roof leaks and the landlord takes a couple of weeks to fix it, you get to move out when you want to and stop paying rent when you want to, because it doesn't say that. So we've proven, just read the lease. We've proven the lease was breached. In fact, one of the things that the judge is going to read you guys that you're going to take back with you, the attorneys, the parties in this case, have entered into a set of stipulations. And stipulation is a word that's not just used in courtrooms, not just used by lawyers. You guys probably know it, but it really just means agreements. It means these facts, we are agreeing these facts are established without the need for any proof. That's what it means. The lease was signed. The amendment to the lease was signed. February 2019, the defendants vacated the premises. February 2019, the HYH stopped paying rent. We agree on that. No need, and they testified to all that stuff. So when it comes to the plaintiff's burden of proof, I would submit to you that that burden's been met. And once again, we're not talking about beyond a reasonable doubt. This isn't law and order. This isn't, SVU. This is a civil case. So this isn't beyond a reasonable doubt. It's preponderance of the evidence. And I explained to you guys, that just means more likely than not. It means if the scales of justice are equal and you drop a feather on one of them, you've met your burden of proof. That's it. 50.00001% satisfies that burden of proof. Once the plaintiff meets its burden of proof on a claim, the burden then shifts to the defendant. If the defendant asserts a defense, like, for example, constructive eviction, the defendant bears the burden of proving that a constructive eviction occurred. The plaintiff doesn't have to prove that it didn't occur, but I think that we've done that anyway, and I'll get to that in a moment. So I just want you to know how burden shifting works. So let's get into constructive eviction. Because this, out of all of the slides in this PowerPoint, we only have a few more. This is the one that I would imagine the other table is worried most about. And I told you guys in opening a little bit about constructive eviction, but in commercial cases, even as a lawyer, I will tell you, the standard shocked me how high it is for constructive eviction. I mean, it is almost impossible for Georgia courts to say a commercial tenant has been constructively evicted. I'm telling you guys, it is insanely high. Georgia law says, and there's not a whole lot of cases that deal with this, but the ones that do are all crystal clear. They basically say that it has got to, two things. Number one, it's got to be permanent and incapable of being repaired without basically stopping the tenant's business, number one. And number two, it's got to be combined with the landlord's intent to deprive the tenant of the premises. Well, those two things, they have the burden of showing that. They didn't meet the burden of showing that. There's been no evidence that the landlord didn't want them in the premises. In fact, we were doing everything we could to keep them in the premises. We were surprised that they left. They didn't tell us. And number two, we know they weren't permanent because everything was fixed. Well, how do we know that? There's evidence of it. Number one, you'll see, and this is relevant for damages, two of the things you can be taken back to you, two of these little documents over here sitting idly on this little witness stand still are a new lease for the new tenant and an extension for that new tenant for this exact same office suite, 350 North. Well, what kind of business, I wonder, rented this exact same office suite that the defendants claimed was they were permanently evicted from? It's a tax and accounting firm. That's who's in there now. And not only did they move in just a few months later, after being there for 3 years, they did the same thing they did. This new tax and accounting firm who deals with the same IRS Circular 230 information, they re-up for another extension. All of these issues were fixed. The few cases that deal with constructive eviction basically say if it was repaired, that shows there wasn't a constructive eviction. That's what that means. Basically, if it's repaired, then what you should have done at most is either, like I said, self-help, deduct from your rent, fix it yourself, or sue your landlord for diminution of rental value. You can do that. You can be compensated. You do have a remedy. But if you're a company, outside of this, you're stuck in the premises until the end of the lease term. And if you move out, you're in breach. So let's look at these repairs. You guys are going to be sending this back. And yes, there were more invoices. And yes, we didn't produce those. Honestly, just like there were more bank statements. My client thought that 4 days of talking about a lease was probably 3 days too many for most of you. But the evidence is going to show this. And this is all contained in this stack of paper with yellow stickers on it right here. And by the way, we've seen these photos. I just, once again, want to point out the timeline here. We've seen a few photos of like ceiling tiles falling through because water's leaking and water in the bathroom floor. And again, we've never denied it. This was a headache my client didn't want when they bought this building. There's an email in there that I talked about yesterday where just a month after my client purchased this building, their employees spent the entire night making repairs to this stuff because they didn't know what they were getting when they bought this building. And as soon as they figured it out, they immediately began work, calling in their contractors, getting the building in shape. These are in the emails. This is all the stuff that we did for them. And not just them, all the tenants in the building, but every time a roof was leaking, we had it patched. Did it leak again a few times? Yeah, it did. That's why we paid $200,000 after 4 or 5 tries to patch it. We're like, you know what? Just put the whole new roof on. Like, that's it. We're not dealing anymore with patches. It's not working. Let's fix it. So they did. Lights went out, they replaced it. The sound dampening insulation and sealed window mullion, I just want to point out, once again, there is no legal obligation to do that. Once a commercial tenant says we accept it as is, that includes noise levels. We didn't have to do that legally at all, and we did it anyway at our expense, just to make them happy. Repaired ducts, eliminated that buzzing sound. The building's chiller at one point, we talked about HVAC stuff. The building's chiller at one point, like the power system, I'm not HVAC tech, but I know like this big module that powers this thing. At some point, they were having enough issues. They did the same thing for that, and that wasn't cheap either. They replaced the entire module that powered the HVAC that cooled the entire building. And they want to use all of this evidence to show that there were issues. I want to use all of this evidence to show that those issues were addressed. Because we agree that the issues occurred. The point that we're trying to make is we jumped on it and we fixed it. Dried carpets with commercial blowers, shampooed and cleaned carpets, replaced ceilings. They said that they smelled, a weird smell. That adorable French guy that came in said the same thing. But when you look at the evidence, my client couldn't replicate these issues. Like the noise levels were the same. There's an email in here that you'll see where Denise Hahn called the management office, which by the way is in the same building. The management office is in the same building. So my client works in the same building that they worked in. There's an email where she calls in the morning and says, I can't stand the noise from the Suntrans suite next door. 30 minutes later, the property manager goes to the Suntrans suite and says, I don't really know what she's talking about. There's one person in there and nobody's talking. And they went in there a couple of times, couldn't replicate it. And when they did hear, like Mr. Walker testified, when they did hear some noises, it was like in the conference room next to him, it was like, that's what commercial offices sound like. And it's like normal. It's not out of the ordinary. The smell, there's emails in there. I went to check the smell. They were like, I don't really know what she's talking about. I can't smell anything. I went in there and it smells fine. That being said, the whole building, there's evidence of this too. The whole building had air fresheners that they were replacing every month, but they couldn't replicate it. And if you go through these emails, you'll see something else too. Whether it's the demand letters from their lawyers at the end of 2018 or emails from Mrs. Hahn, the reason why they have to leave kind of changes depending on when it is. In January, after the new roof had been replaced, it was the noise levels. You'll see that email in it. We have no, noise levels, confidential information. We can't afford someone to hear a social security number. And apparently if you work tax and accounting, you have to blurt out loud social security numbers all day. So we have to leave. But before that, it was the water. And before that, it was something else. The point is, she testified, Ms. Hahn testified that when all of this stuff was happening, they had already created a new company and started planning to buy an office building. TMS had already gone broke and moved out. All this stuff had happened. That's why I wanted to ask you to ask yourselves this question. Did they move out because of this narrative, or did they create this narrative so they could move out? So they replaced the ceiling tiles, steam cleaned the carpets, moved their furniture for them. The defendants, everything that they needed has been, I would argue the evidence shows they've been provided. Yeah, he slipped and fell in the bathroom, or he claims to have. No one saw it, but no one's saying he didn't. No one's saying he wasn't hurt. We don't know either way. What we do know is he was paid more than $250,000 for it, and that was a separate case. This isn't a slip and fall case. You're not going to be bringing any medical records back in the jury deliberation room with you. There's a reason for that. It's not relevant in this case. So as Mr. DeBond said, it's your job to weigh the credibility of the witnesses. If two people say two totally different versions of the same story, unfortunately, the burden falls on you guys to decide who you want to believe. Like, who do you want to believe? And out of what they say, what do you want to believe? Like, you have to determine, do I buy into this? Do I not? Do I believe this person? Do I not? Are they trustworthy? Are they credible? Does this make sense? Does this pass the smell test? No pun intended. So I just wanted to point out a few examples that have been part of the record in this case. Number one, both defendants, when they were asked, have you ever commingled funds between your companies for shared expenses, or to pay one company to another and transfer money in between? Or have you ever used company accounts or money to pay a personal expense? They didn't say, oh yeah, we did that, but we always kept good records. They could have said that, but they didn't. They said no. And to their credit, they stuck with their story, because that's the same thing they said when I asked them that question in June of 2024. They said no, never. And then came the bank records, and then came Old Navy and Macy's. And I'm sure that they would like for you to believe that they were always using their personal Old Navy card to buy office supplies for their tax business. But there's no record that any of that stuff was related to the business. What there is evidence is they were paying their personal cards on a regular basis with their company account like it was their own checking account. And it might as well have been, because there were also records of them putting money into their personal checking account and not knowing how to explain it. All of that is in the evidence that's been admitted. Mrs. Hahn testified that when she sent my client her letter in May of 2022 saying HYH2, my tax company, we don't owe you anything because we didn't sign a lease with you. So you better leave us alone. I asked her point blank, at that point in time, did you have any reason to think that you and your husband might be personally liable for the HYH consulting lease? She said, no, no reason at all, not one reason. When you look at Exhibit P37, we looked at it. The same lawyers, the same law firm, Deming Law, I'm familiar with that firm myself, the same lawyer that she paid to send my client 2 demand letters threatening them, sent her an email saying, and you'll be taking this back with you, and I'm going to quote here, "Dear Mrs. Hahn, if proper procedure is not followed and the business has been terminated," talking about HYH Consulting, "then liability for the debt falls to the owners of the LLC at the time of termination." By the way, that goes back to the fraudulent conveyance and breach of fiduciary duty. That's why they said that. That's how the sausage is made when it comes to lawyers giving legal advice. They also said, as stated earlier, HYH Consulting LLC does still have liability for the remaining term of the lease if a lease termination was never signed when you moved out. And if HYH Consulting LLC was not properly terminated, then the then current owners will have liability even if a personal guarantee was not originally signed with the lease. That's April 25th, 2022. Their own lawyer told them that they're on the hook. And she looked at me under oath and said, we had no reason to think that we could ever be personally liable for HYH's lease, other than our attorneys told us that we were, of course. There's an email where my client saying, hey, we can't get a hold of TMS. You guys personally guaranteed it, so that's why we're communicating with you guys. Not only that, but Mrs. Hahn admitted she had been the liaison between the landlord and TMS. So that's why we reached out, hey, we're the Rachel and Sean from TMS. Trying to get in touch with them. We don't know where they are. I think they moved out. They're behind on their lease. Well, looks like she sent an email when she told them, I can't speak for them. I'm not them. And then she forwarded that email to her husband, and you'll take that email back. And she said, management can't catch them anyway. I think I have to give them their email address, but management can't catch them anyway. Our purpose is just to delay time. And at first she couldn't explain that, right? I think it kind of surprised her. And eventually she's like, no, I think about that. I think it was delay time because of, this and that. And it's your job to determine who to believe. That's my point. Mrs. Hahn claimed that her tax and accounting company, HYH Consulting 2, oh, no, we were a tenant too. See, when you look at the lease, it says that HYH Consulting was allowed to run a tax and insurance business out of the premises, right? Yeah, but not your tax business. HYH Consulting 2 didn't sign the lease. Well, why does that matter? If like Mr. Devon said, it doesn't matter what hat you're wearing. Well, it matters for the exact same reason that Mrs. Hahn thinks it matters. When we asked her for unpaid rent from HYH2, that's why she sent this letter. You know what? HYH Consulting 2 did not sign a lease agreement with your company and have never engaged in business with your company. We do not have any liability whatsoever for this assertion of claim. Your claims are frivolous and needs to be withdrawn. That's why it's important, actually. That's why you keep companies separate, because companies are different. It matters for tax reasons. It matters for liability reasons. It matters for contract reasons. If you don't sign a contract, you're not liable on the contract most of the time, unless you're a third-party beneficiary. There's no, lawyers call that privity. She knew that, and that's why she refused for HYH2 to pay any rent. Because guess what? HYH2 didn't sign the lease. And she wants you guys to believe that my client was totally cool with HYH2 and her company and all of the other family companies using this premises, even though the lease specifically says the opposite. She wants you to believe that, no, that was okay. That was all right because it says tax and insurance business. But when it came time for the other companies to be liable, no, we're not on the lease. That's someone else's problem. It matters. They filed, when they dissolved HYH Consulting, also, by the way, during the term of this lease, they filed their notice of termination, which has to be sworn under oath with the Secretary of State Corporations Division. Just like you register to do business, you have to register to stop doing business. And when you do that, anyone that's closed the company will know this, You have to provide the Secretary of State with a sworn statement that there are no outstanding debts or liabilities whatsoever for this company. And yet, not only did they know that they had been demanded unpaid rent from my client, a year and a half later, they're using their other company's checking account to continue paying off HYH Consulting's credit cards. It's your job to weigh credibility. So what are the damages we're asking for? You're not being decided on to determine if you're being asked to determine whether or not you're going to award my client attorney's fees, which, by the way, the lease says we're entitled to if we prevail. But you're not being asked to determine the amount. That's going to be handled separately by the parties in the court. It's your job to just say you either are entitled to some attorney's fees or you're not. It's going to be a yes or no question for you. But the damages, we are asking for $118,937.89. Now, I want to point something out. Mr. Devon said that my client has the gall to ask them to pay to replace this carpet. Here's the thing, though, that's not really true. If you breach a commercial lease and you vacate the premises before the end of your lease term, most commercial leases say this, and by the way, even if they don't, Georgia law says this. The landlord, one item of the landlord's damages as a matter of law, if there's a breach like this in a commercial lease, is whatever the costs are incurred to relet the premises. And when someone's been in the office suite for 7.5 years, that normally includes changing the carpet. So that's why it's in there. And by the way, normally when you stay till the end of the lease term, you don't have to pay the broker commission for the new tenant. You don't have to pay for the suite to be repainted. That's why it says normal wear and tear accepted in most leases. That's something the landlord does. The only reason why we're asking them to pay for this stuff is because they breached the lease and we had to find somebody while this office sat empty. That's why. So we're asking you for unpaid rent and late fees, accrued interest through Monday, by the way, cost to clean and repair, brokerage commission, and we're asking you to select yes for attorney's fees. So the total amount of compensatory damages that we're asking for is $118,937.89. Now, you heard there's punitive damages claim. I want to be clear about something. The judge is going to explain what the law is in terms of whether or not punitive damages should be awarded, and that's going to be up to you to decide whether that's even an issue in this case. The only thing I'm going to point out is punitive damages are not subject to any calculation, or you can't just plug them into an Excel spreadsheet. There's no multiplier. This isn't like an algebra equation and you just have to solve for X. Punitive damages, really, the standard for that is the enlightened conscience of an impartial jury. If you decide to award punitive damages, the amount is determined by that, your enlightened conscience. That's a fancy lawyer's way of saying whatever you guys think is fair. And so I just wanted you to know that there is no multiplier. That's just whether or not whatever amount that is, whether it's $5 or $500,000, whatever amount you think is fair for that. And the only reason why that's even part of this case is because under Georgia law, when you have a voidable transfer act, the law sees that, as I told you, as a variation of fraud. The same thing with breach of this type of fiduciary duty. The law says that if the jury decides it, those two claims can also incur liability for punitive damages. About to wrap up, but I just wanted to show you guys this. So this is the verdict form that you guys are going to be asked to fill out together. Now, at the end of it, I told you guys, first thing you're going to do is select a four-person. Once you decide how you're going to fill this form out, the four-person signs it, dates it, right here at the end. But you have to go through, there's 3 pages here. You're going to have to go through and check off boxes, all right? So what we're asking, and this should be obvious, but as you go through, my client is asking you to find in favor of the plaintiff and against all defendants on each one of these claims. When you get right here, you have to choose between actual damages and nominal damages. So here's what nominal damages mean. Under Georgia law, if a contract is breached, if a wrong is done, even if there are no actual damages, the party that's been injured is entitled to what's called nominal damages. That means like cost of defense or some amount. There's no definition for that. Again, it's whatever you guys think is fair. But it's just like trespass, right? So the law protects property rights. If your neighbor goes onto your property and back, you don't have any damages. That didn't hurt you. It might have been a couple of blades of grass, but the law says that property rights are so important that in a trespass like that, even if you have no damages, we're gonna give you something. Because it's symbolic to show that that right is important. Same thing with contractual rights. Even if the plaintiff proved no damages, if there's a breach, the law says you can give them something just to show that that right's important. We're actually asking you for actual damages. That's why I showed you that number. We're asking you to put that number in that blank. Right? Again, I appreciate all of you guys for paying attention. I know this has been extremely dry and boring. I know that my client is the plaintiff. I know that my client filed this suit, but I promise you my client didn't want to. Any of you that own businesses know, like the last thing you want to get at the end of each month is an envelope with another bill from your lawyers. It's not good for business. It just means, and by the way, you're not guaranteed to even win. You're doing that because you're standing on principle for what you believe in to get the benefit that you bargained for in a written contract that someone signed and then broke their promises. It's the same reason Mr. Hahn sued GIA when they didn't pay him the money that they promised when they signed his contract. That's what my client wants. So, and that's why we're asking you to award my client its damages and find in favor of my client on its claims and against the defendants. Thank you guys so much for your attention. I appreciate all of your patience.
Thank you, counsel. Members of the jury, it's now my job to charge you on the law that applies to this case. That process takes about 15 to 20 minutes. Anyone want a break before we dive in? We've got one request here and there. So just let us know when you're ready to proceed. All right, we'll be off the record in recess until the jury is ready.
And that thing got down to like 6 minutes. I was like stressing.
Awesome job.
Is that okay? Or
Yeah, I don't care. I ran out.
I did too. Oh,
Bother you, I mean.
who was like,
That's all right, I'm cute, by the way. I don't know what that is.
yeah, that like rock star guy or whatever. The guy that we were gonna let go. He was
Oh
like,
my goodness.
yeah, yeah, right on, brother. I'm like, heck yeah. I kept looking at him because I'm just like, yeah, fuck yeah. Fuck yeah, bro. He was like,
Chapo.
totally. He was eating.
I'll take a bigger cup then.
I mean,
Well, the espresso does
everything I
do
said,
a-
I noticed
do
at the
an
beginning. It was
espresso.
like, yeah, that makes
I'll
sense.
take
Man, I like
Okay,
that.
I'll make it how I
So I
like
started
it.
kind of like paying
Please,
attention.
literally, I will drink it.
Dude, I thought he
Thank
was gonna
you.
be like, let him cook, guys. Let him cook. Did you? Yeah, no, I don't know. I think I know who you're talking about.
Yeah.
I could not get a beat on shit. Look at that. Like that. I will quickly divide up the ones that are really tuned in and I'll focus my eye contact on them and I'm kind of like depending on them to bring it home. But like if I can get a beat on somebody, if they're just glass based, I mean, I look at them so they're not feeling like I don't care about them every now and then, but I'm focusing my effort on the ones that I think are, anyway, how long did we?
I don't even know. I've done probably 15 minutes. What it's
All
usually
right.
been.
When the jury starts deliberating, it usually takes at least 45 minutes to an hour. It can take a few hours. One thing I can guarantee, it will be done today. But while the jury deliberates, you're going to try. Yeah. Okay, so you know this. I'm just gonna stop there on the bench.
Okay.
Because as soon as the jury reaches a verdict, that deputy's gonna come out and tell us, and then we'll have to come in here with the jury to, so you can,
Can't leave.
You can go like get a snack or something, but I was taking the courthouse. Huge. So there's a call on. Strategic message in this case. Told my car.
Well, yeah, that's awesome. We're sitting out for up there. Awesome. All day. Yeah. Oh, that sounds good. Oh.
Mr. Merritt, as we're killing time here, if you could start compiling all your exhibits
Okay.
that you think would need to go back,
Actually, I think they're all.
just put them all in order, 1 through 30-ish, and we can audit them later. Six. Classmates here.
I've known her for like ever.
Are you one of the ones, she was telling me that folks from Court School were like texting her with screenshots when they saw her on TV or
Oh,
anything like
she on
that.
the news?
Well, just because she's always right there, you know?
It would be a picture of him and then her. Right, yeah.
With
I've been on the
flags.
news once and it's when they arrested somebody for a different. car.
Oh, wow.
It was at 11:45.
I remember that one. Where do you find yourself going most these days? Is it just depositions or you come to court?
Mostly Deborah work. I used to back in the day. Other reporters hate coming to court.
And it can be a lot.
I don't know, I find it interesting. I'll do, and I live close by. That helps.
Do you still bill at the same rate, whether it's a depo or a trial work, an hour's an hour? So you end up making more of depositions, even though it's like little smaller chunks of time.
Very rare days. But
Hmm.
it's not as interesting. I don't.
It's just, they're going down every little rabbit hole. What? What? We were talking about toilet manufacturing in that case?
You know, twice as long because it would have to be interpreted. A lot of it. Not to be weird. And that's when the attorneys usually don't get along. They're pouring at each other.
Yeah, and they're not on good behavior. Like, yeah.
For sure. You really are. The things but I gotta dig have some.
Oh, really? What are you doing with the feds
It's a bank.
out that world?
I'm interested that you.
Yeah, yeah, you really do pop around, kind of see everybody, huh?
Atlanta's got so much. I like it. I like court. I don't know if I could do a full time.
Well, we're not going to trial every week. Face it out. Yeah, well, we've actually, so far, we've only had to do 2 of those in 3 years. And they weren't like 2 full weeks. They did on like a Wednesday. I think. So 8 days, I think, is our max. Actually, then Linwood go to Thursday, so maybe 9 days. Deliberations. Stretched on. But no, I don't know. I mean, some of these ones, when you start stretching to like the 3rd week, it would just be like, what are we doing here? So, actually, Deputy Scott, can you go try to track down Deputy Scott? Scott, can we go track down defendants? What's the longest one? Have you ever had to do it? Do you usually, because we've had a different person every single day. Is that typical?
Yeah, I think because if it did get ordered. That person.
Oh, you could both do it so much faster that way. Oh, that's brilliant.
I did, I was supposed to do a 5-day custody hearing a couple weeks ago, and they settled that.
This is the first time I've had that though, where it was someone different every single time.
Yeah, it does help. Like, I don't mind
Yeah.
doing all the days, but if they order it, I mean, I gotta take.
Yeah.
I'm not used to it.
Just on average, how long, if you had a full day of court, full day of trial, exhibits, testimony, whatever, not just closings. How long would it take you to sit there and proof it and finalize it?
Usually
For
like
1 day
2
of
hours.
trial.
Look through the exhibits and put them in order. So I put mine in order and I put all of
If
theirs
we
in order,
do
and I just stack them
6
up.
hours, or if we're in
So
court
I
for
don't know if you
7
want to go through
hours,
them.
that takes 14 hours of uninterrupted work.
For me, some people are like
No,
really
no, he just
rock
asked
stars
the
and send it
Yeah.
off. Like, I would-
you guys.
So you're right, would you say you're right there in the median at
Yeah,
least?
I'm going into 8 years of reporting.
Yeah. So 14 hours would mean 3 days, assuming like no one's even coming and interrupting you and you have no fires.
And the weekend, and I work.
What Kamisha says, it's incredible to hear.
Oh, no.
What's that?
Constantly, which is why I don't mind being around.
Yeah. I can't be the
I'm honest.
maintainable.
Did you see?
Um,
Sorry, I don't have kids.
No, I did that in a prior trial.
Oh,
But I mean, I keep,
yeah, I've never seen it. I was wondering what you were doing and I was like.
they,
oh, that's good.
Kamisha and I have been having this. Yeah, she's not happy about it, but I'm like, we're just
And
gonna
it
have to
tracks
do
your
this.
attention. It, like,
Where
forces you to look
for
at
these
it.
guilty pleas that we never need
Forces you to
transcribed.
look at it.
And she's forced to sit here all day and just take one after another after another. And they just passed that statute that says I can just record them. I think we're gonna roll with that because their time's too valuable. you know?
Is she a boyfriend or step?
It's
I
kind of
didn't-
forces you
Okay, I
to
thought
Yeah.
have to
she
look at
she
it,
was in
because you're
Steno
like,
with me,
what's
but I
that?
didn't know
Yeah.
she switched.
No, she's doing Steno.
Which
And she
unit?
promises me one time I'll have real
I have to
time
go
up here
first,
so I
that's
can
what I
follow
do.
along.
Yeah.
She's working on it. I know she will. But,
Said like-
but yeah.
He said like, how wet's the part out?
Was she really?
Always
I thought it was
overshooting.
He was, he
Always
started him, I was like, what did he say about it? I was like,
Oh, well,
yeah.
All right, council, before we go back on the record, I'm just making sure, expectation is, y'all audit each other's exhibits, get yours in numerical order, stacked, ready to go. And we'll put it on the record after the charge. If you have any concerns, objections, we gotta work through anything. Otherwise, y'all just give me the stack. I'll put mine on top of it and then we'll send it back, okay?
All right.
If you want to, you can sit there during the charge if you want to, or whatever, if that's all you're doing. But otherwise, I think we're ready to charge the jury.
Yeah, and I've already verified that those exhibits are correct on both sides.
Okay.
Do you mind if I sit here and look through?
Yeah, of course, that's fine. So, let's go back on the record here.
Oh, real quick before we do, Miguel, just FYI, the only one that I took out was that Wells Fargo receipt because you never tendered that into evidence.
Okay.
So I brought that back here to stick it in the, I didn't know.
Yeah,
if you
just
were
leave it on the top of my desk.
Okay.
Thank you.
All right, if that's an issue you want to bring up on the record or address, we can after the charge when we're making sure we are on the same page with exhibits. So, all right, we're back on the record. All parties and counsel are present. Jury appears ready to proceed with the charge. And so I'll ask Deputy Scott to retrieve the jury.
All right, the jury.
Deputy Scott, please be seated, everyone. All right, members of the jury, settle in. It's now my obligation to charge you on the law that you are to apply to this case. And so I charge you as follows. You will receive a written copy of these charges for your deliberations. You are considering the case of American Capital Properties LLC as plaintiff versus HYH Consulting LLC, Han Corporation, Bo Yun Han, and Young Ha Han as defendants. Plaintiff filed this action here in the Superior Court of Fulton County, in which it brings claims for 1, breach of contract against defendants HYH Consulting LLC, Bo Yun Han, and Young Ha Han only. 2, voidable transfer against all the defendants. And 3, breach of fiduciary duty against defendants Bo Yun Han and Young Ha Han only. The plaintiff must prove every essential part of its claims by a preponderance of the evidence. This is sometimes called the burden of proof or the burden of persuasion. A preponderance of the evidence simply means an amount of evidence that is enough to persuade you that the plaintiff's claim is more likely true than not true. If the proof fails to establish any essential part of a claim by a preponderance of the evidence, you must find against the plaintiff. When more than one claim is involved, you should consider each claim separately. In deciding whether any fact has been proved by a preponderance of the evidence, you may consider the testimony of all of the witnesses, regardless of who may have called them, and all of the exhibits received in evidence, regardless of who may have produced them. If the proof fails to establish any essential part of the plaintiff's claims by preponderance of the evidence, you must find for the defendants as to that claim. The burden of proof for an affirmative defense, however, falls on the defendant to prove by a preponderance of the evidence. Evidence is the means by which any fact that is put in question is established or disproved. Evidence includes all of the testimony of the witnesses, as well as the exhibits admitted during the trial. It also includes any stipulations, which are facts agreed to by the attorneys. Evidence may be direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as by personally observing or otherwise witnessing that fact. Circumstantial evidence is proof of a chain or set of facts and or circumstances that tend to prove or disprove another fact by inference. That is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. Direct evidence is evidence that immediately points to the question at issue, and circumstantial or direct evidence is evidence that only tends to establish a fact. It must be such as to reasonably establish that fact rather than anything else. The comparative weight of direct and circumstantial evidence on any given issue is a question of fact for you to decide. The parties have entered into stipulations that have been approved by the court, and these are outlined in Court's Exhibit 4 in written form, and those will be provided to you in your deliberations. When the parties stipulate facts with the approval of the court, that is in the nature of evidence, and you must take that fact or those facts as a given without the necessity of further proof. Sometimes evidence is admitted for a limited purpose. Such evidence may be considered by the jury for that sole purpose or the issue for which the evidence is limited and not for any other purpose. You, the jury, must determine the credibility of witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. The credibility of a witness may be attacked by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in the witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. When a party has evidence that rejects or disproves a claim or charge made against the party, and he or she fails to produce it, or having more certain and satisfactory evidence relies on that which is of a weaker or inferior nature, a presumption arises that the charge or claim is well-founded, and this presumption may be rebutted, however. If a party fails to produce an available witness, the jury shall determine whether such a failure warrants the inference that the witness, if produced, would have testified to facts prejudicial to the party failing to produce the witness. Regarding count 1, a contract is an agreement between two or more parties for the doing or not doing of some specified thing. A contract is breached by a party to it who is bound by its provisions to perform some act towards its consummation, and who, without legal excuse on his part and through no fault of the opposite party, declines to do so. A corporation possesses a legal existence separate and apart from that of its officers, and the mere operation of a corporate business does not render one personally liable for corporate acts. Where a party has overextended his privilege in the use of a corporate entity in order to evade contractual responsibility, the corporate veil may be pierced to render the individual defendant liable. There must be evidence of abuse of the corporate form. You must determine whether the defendant disregarded the separateness of legal entities by A, commingling on an interchangeable or joint basis, or B, confusing the otherwise separate properties, records, or control. Sole ownership of a corporation by one person or another corporation is not a factor, and neither is the fact that the sole owner uses and controls it to promote his ends. Whether Bo Yun Han or Young Ha Han may be held personally liable for a breach of contract is a matter for you to determine. A party to a contract may waive contractual provisions for its benefit. A waiver must be agreed to by all parties to the contract. All the attendant facts, taken together, must amount to an intentional relinquishment of a known right to find that a waiver exists. The burden of proof lies with the party asserting that a waiver occurred. Two essential elements must be shown to establish the defense of constructive eviction. They are: 1, that the landlord, in consequence of his failure to keep the rented building repaired, allowed it to deteriorate to such an extent that it had become an unfit place for the defendant to carry on the business for which it was rented. And 2, that it could not be restored to a fit condition by ordinary repairs, which could be made without unreasonable interruption of the tenant's business. Put another way, to constitute an eviction which will operate as a suspension of rent, there must be either an actual expulsion of the defendant or some act of a grave and permanent character done by the landlord with the intention of depriving the tenant of the enjoyment of the demised premises. An act may be considered grave in character if it renders the premises untenantable or unfit for the use and benefit of the tenant and accomplishing one or more of the substantial purposes of the lease. It must be shown that the tenant's use and enjoyment of the premises is not merely rendered uncomfortable. Damages are given as compensation for injuries sustained. Damages recoverable for a breach of contract are such as arise naturally and according to the usual course of things from the breach, and such as the parties contemplated when the contract was made as a probable result of the breach. In every case of breach of contract, the party not breaching it has a right to damages. But if there has been no actual damage, the plaintiff can recover nominal damages. Nominal damages are a trivial sum, important for the fact of the award, but not meaningful in amount. As to count 2, a transfer made by a debtor is voidable as to a creditor, whether the creditor's claim arose before or after the transfer was made. If the debtor made the transfer, 1, with actual intent to hinder, delay, or defraud any creditor of the debtor, or 2, without receiving a reasonably equivalent value in exchange for the transfer, and the debtor, A, was engaged or was about to engage in a business or transaction for which the remaining assets of the debtor were unreasonably small in relation to the business or transaction, or B, intended to incur, or reasonably or believed or reasonably should have believed that he or she would incur debts beyond his or her ability to pay as they became due. When a voidable transfer is committed by a corporation, an officer who takes part in its commission, who specifically directs it to be done, or who participates or cooperates therein is personally liable, regardless of whether he personally profited from the wrong. An officer of a corporation who takes no part in the commission of a voidable transfer by the corporation is not personally liable unless he specifically directed the personal act to be done or participated or cooperated therein. Whether Bo Yun Han or Young Ha Han may be held personally liable for voidable transfer is a matter for you to determine. In voidable transfer actions, there may be aggravating circumstances that may warrant the awarding or imposing of additional damages called punitive damages. Before you may impose punitive damages, the plaintiff must prove that the defendant's actions showed willful misconduct, malice, fraud, wantonness, oppression, or that entire want of care that would raise the presumption of conscious indifference to the consequences. The plaintiff must prove that the defendant is liable for punitive damages by a higher standard than that for proof of other damages. That is, by clear and convincing evidence. If the plaintiff fails to prove by clear and convincing evidence that the defendant was guilty of willful misconduct, malice, fraud, wantonness, oppression, or entire want of care that would raise the presumption of conscious indifference to consequences, then you would not be authorized to impose punitive damages. Mere negligence, although amounting to gross negligence, will not alone authorize an imposition of punitive damages. Punitive damages, when authorized, are imposed not as compensation to a plaintiff, but solely to punish, penalize, or deter a defendant. In your verdict, you should specify whether you do or do not decide to impose punitive damages. As to count 3, the managing members of an insolvent limited liability company owe a fiduciary duty to the company's creditors to conserve and manage the remaining assets of the company in trust for the benefit of those creditors. If a managing member of an insolvent limited liability company breaches his fiduciary duty to the company's creditors by making an improper preferential transfer of company assets to himself, a creditor may bring an action. A debtor is insolvent if, at a fair valuation, the sum of the debtor's debts is greater than the sum of the debtor's assets. A debtor who is generally not paying his or her debts as they become due, other than as a result of a bona fide dispute, is presumed to be insolvent. The presumption imposes on the debtor the burden of proving that solvency is more probable than not. Assets to be considered do not include property that has been transferred, concealed, or removed with intent to hinder, delay, or defraud creditors, or that has been transferred in a manner making the transfer voidable under this law. The expenses of litigation are generally not allowed as a part of the damages, but if the defendants have acted in bad faith or been stubbornly litigious or have caused the plaintiff unnecessary trouble and expense, you may allow them. Bad faith arises out of the transactions upon which the complaint is based and refers to a time period prior to when the lawsuit was filed. Bad faith is not simply bad judgment or negligence, but it imports a dishonest purpose or some moral obliquity and implies conscious doing of wrong. And it means breach of a known duty through some motive of interest or ill will. Stubborn litigiousness and causing the opposing party unnecessary trouble and expense refer to forcing a party to file a lawsuit when there is no bona fide controversy. If there is a bona fide controversy between the parties, expenses of litigation should not be awarded, unless you find that the party against whom the fees are to be awarded acted in bad faith. I want to emphasize that anything I said or did during the trial of this case was not intended to and did not intimate, hint, or suggest to you which of the parties should prevail. Whichever of the parties is entitled to a verdict is a matter entirely for you to determine, and whatever your verdict, it must be agreed upon by all of you. The court's interest in this matter is that it's fairly presented according to the law, and that you, as honest, conscientious, and impartial jurors, consider this case as I have instructed you, and return a verdict that speaks the truth as you find the truth of this case to be. Your verdict should be a true verdict, based upon your opinion of the evidence according to the laws given to you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, economic or corporate status, for or against either party. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use the electronic device or media to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. Your verdict must be unanimous. One of your first duties in the jury room will be to select one of your number to act as foreperson, who will preside over your deliberations and who will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Jurors should carefully consider all the evidence in the case and deliberate with a view toward reaching a unanimous verdict consistent with your consciences and oaths as jurors. Avoid premature, fixed opinions. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should never surrender honest convictions or opinions in order to be congenial or to reach a verdict solely because of the opinions of the other jurors. Do not begin your deliberations until I send you the exhibits and verdict form, which I will do so shortly, and then you may begin your deliberations. With that, is there any objection to the charge as given on behalf of the plaintiff
No, Your Honor.
or on behalf of the defendants?
No, Your Honor.
All right. And so, as I mentioned, members of the jury, you're going to be provided the exhibits in this case, a copy of the charge I just gave to you, and a copy of the verdict form that was referenced during closing. Again, I would instruct you just to work your way from the top, go down. There would be instructions on how to fill this out at certain points. You may not have to answer count 4, depending on how in your findings you'll follow along. But in each of these claims, when you do see an or, the expectation would be that you're filling out either the top half or the bottom half or some mixture in between there. So don't leave any blank untouched unless instructed to otherwise. And as I'm told also that lunch is here. So if you would like, you can go ahead when I excuse you to the back. I think go ahead and make your way into the hallway to start grabbing a plate if you'd like. Or you can, my first want to do is go back and decide as a jury whether you want to break completely for lunch, whether you want to work through lunch. It's all up to you from here on out. Just if you do decide to leave the building or take a break from deliberations, keep us informed through Deputy Scott so we can keep track of how long you've been working and where you are. And the last thing I would instruct you is that you may now retire to the jury room with, but I would ask juror 34 to stay behind with us. Thank you. I did scratch out.
I was going to say something about that.
All right, juror 34. As you may have guessed, we had 13 jurors with us, but only 12 constitute the jury that we need. So you were our alternate. The reason we have alternates is because I've had it several times come up in the middle of trial. Emergencies happen. A juror doesn't show up. A juror has a medical emergency, and so we need to sub in the alternate. And if we didn't have an alternate, the whole trial could be a waste if we only have 11 people. But that doesn't mean you're off the hook just yet, because I've also had to sub in alternates in the middle of deliberations before. All right. So how I would like to handle this is that feel free to go back with Deputy Scott, collect everything, all your belongings, get some lunch if you want to, but I'm not. But then you're free to leave. And I would ask that you're still under the obligations of your service, meaning you may get a call from us asking you to come back and rejoin us if we need you. If the case is concluded, we get a verdict, then we'll call you and let you know you're off the hook. But generally speaking, if you can remind me, how far of a drive is it from home to here for you?
Milton.
So a good ways. Assuming this is midday, is that about an hour and a half, 2 hours away?
An hour each way.
Okay. So what I would just ask you to do, if you could stay within an hour and a half of the courthouse until you get that call from us, letting you know that you're off the hook completely. In all likelihood, if we have to summon an alternate juror, it's probably because deliberations stretched into Friday. And it would be Friday morning, we just come back and start fresh with you. And so unless you have any questions, concerns for me, I would say thank you so much for your time with us today. Likelihood is that we won't be seeing you again, but please remember not to discuss the case with anyone or do any research until you get that phone call from us, okay?
So today, it won't be today. It will be tomorrow if I get a call.
Most likely, unless there's some emergency that comes up in the next hour, we're probably not going to be calling you back today. Unless it's to let you know there was a verdict and you're off the hook completely. All clear?
Okay.
Thank you so much for your time, sir. All right, for the record, I made and read out some line edits on the charge to the jury. I saw there were some references to counterclaim defendants, which is inapplicable here, so I've printed out a new copy omitting that language. Now remarked that and labeled it as Courts Exhibit 5, which I will tender. I'll throw out the old Courts Exhibit 5. I've been handed, any counselor are welcome to review that if they'd like to. I've been handed a stack of exhibits. It appears that it's divided in half with plaintiff's stack of exhibits and defendants, all organized numerically. Anything that needs to be addressed on the record, or is this the agreed sum total of all the exhibits that you believe the jury is entitled to consider their deliberations? Mr. Merritt.
Those look like all of the exhibits that were tendered at trial, Judge.
Your Honor, the only issue I have is Exhibit D30A. Apparently, it was not moved for admission on my part. Let's see whether the opposing counsel has an objection to it, or whether or not it could be admitted at this point in juncture in the trial.
Was that was when she was recalled for the
Correct.
third time? That was part of her testimony. It was handed to her, it was introduced as, or at least referred to as Defense 30A, right?
It was referred to and she was questioned about it, but it was never tendered into evidence and the evidence is closed. So I'm not trying to be difficult, but I would object to reopening the evidence.
Trying to remember if you made I remember at the end of before she was it after her that you made that general motion to admit all unadmitted exhibits? Because you did do that.
It was before that.
I did make a motion to admit all exhibits, but I think I had said that before I had recalled her, but I'm not positive. Because we were debating about
Sure.
rebuttal versus forming his chief.
All right. Other than,
That's my only.
formalism, kind of, Mr. Merritt, what would you say is the reason we shouldn't
other
reopen
than-
the evidence to allow him to tender to move and admit it? Did you actually have an evidence-based objection to this exhibit? I mean, it was referred to and she testified to its contents.
Only that it wasn't in that I can find the exhibits that he was intending to use at trial that were submitted to me in the court in that big folder. So that's the first time I had ever seen it. It was never produced in discovery. It wasn't listed in the pretrial order. Yeah, numerous objections, and it was never tendered in the evidence, which is now closed.
So that I have less of a concern with, unless you can show me how it prejudiced you in some way, since I do think I would have the discretion to allow him to reopen the evidence and tender it if need be. But I think your concerns over notice are well-founded if that isn't case. If that is the case here, was that included in pretrial discovery and?
I wasn't aware it was going to be an issue in terms of them arguing at trial. In terms of, I thought they were going to present an amount that they were asserting was transferred. I never realized that there was not going to even be an issue as to what was transferred or what was the amount that Hank started with. I mean, they had the bank records, they just didn't, it was never requested for the deposit slip for the transaction.
But there's no indication that they ever requested this record or had
Correct.
possession of it.
Correct. I mean, I brought it, although she wasn't called on rebuttal, at that point in the trial, she had already testified twice. I asked her to be called on rebuttal, but we ended up just bringing her back, I think, as part of the case in chief. My main point is, I don't see any prejudice to the plaintiff by its admission.
All right, Mr. Mayor, just last word on that.
I mean, I would just reassert everything I just said,
Okay.
kind of trial by ambush. I know it's that one exhibit, I don't think would make or break the case. But I do think that the law is pretty clear that if you don't, and I would, by the way, say that it was requested in discovery. I can probably point to the request, but I would just argue that for an exhibit that was not produced in discovery, not listed in the pretrial order, not submitted to the court and the other party before trial started as part of your trial exhibits, and I had never seen before, and it was not used for impeachment purposes, I don't think there's any grounds to reopen evidence that is now closed to tender an exhibit that was not tendered during trial, Judge.
All right. Well, while I might be inclined to reopen the evidence if it was strictly a housekeeping matter, I think with some of the, after considering some of the issues you raised there in this particular situation, I would decline to allow that here. I think her testimony covered it, so we could revisit that if the jury starts asking a lot of questions about it. But at this time, motion would be denied for the record. So other than that, is there anything else in the stack that needs to be addressed?
Not for the defense, Your Honor.
From the plaintiff, Judge.
All right, then with that, I've added the verdict form, the charge, and Court's Exhibit 4 with the stipulations. I'll hand that to Deputy Scott and direct the jury, who can direct the jury that they are allowed to begin the deliberations at their pleasure. And we will be in. All right, looks like they're planning, according to Deputy Scott, they've relayed to him that they plan to eat and work through lunch. And so I think we have the contact information for counsel. We'll await further word from the jury and be in recess until then.
Are we allowed to stay in the courtroom?
Certainly. We got nothing else scheduled for today. All right, we're off the record.
Yeah. I don't get hungry during the day, so I'm not gonna eat. Wish I did. Something happens. Either if they reach her, ask a question of the court, but I know that this is one of those cases.
Yeah.
So. All right.
All right.
I mean, probably I'll pop back up and then try to get some work done.
Yeah.
Oh, gosh. Oh, here goes better.
Yes, it's still.
You
For a second, so, but I don't miss
want to give me your cell number?
this was. It's not on my card for reasons like being in court, and not being able to answer.
Right. It's not on your card?
I mean, the office one is, but my direct number,
Mhm.
I'll just give it to you, because and my direct email isn't on my card. Basically for reasons like I'm in court all day and someone needs something.
Yeah.
Can't answer. So I'll just, I'll do. I'm not gonna go far, I just.
Yeah, that's fine. I would imagine you're probably gonna be fine anyway, but just in case something weird happens. Well, I mean, I guess they could have a question that needs to be on the record, but
Yeah, I promise I'm not gonna leave the building even. I'm just gonna
Yeah.
go.
it's not a problem. I think my client went downstairs to get a snack anyway.
I was gonna go to the snack area.
So.
See what that's all about. Well, I know what it's all about, so I'm hoping for good things.
Yeah.
That's nice that they got lunch for them.
Yeah, that's pretty cool.
Yeah, Judge Flournoy used to do that.
Golly, Judge Flournoy, that's a name I haven't heard in a little while.
Doing arbitration stuff. I did a divorce arbitration or custody
Oh, really?
with him 2 years ago.
That's exciting.
These people are crazy.
Thanks.
They're
Kate?
married. Yeah.
Okay, all right. If anybody comes back, I'll text you or,
My handwriting is atrocious.
yeah, 444497260.
I can't read my own handwriting.
Sure.
Are you good? Can I get you a snack?
No, I promise you I'm good. I don't get hungry during the day.
And this is like so.
I know. I mean, I
Why do you
have
get
like,
up there and talk for an hour? I'm like,
actually, I was getting worried that I was running out of time. I'm long-winded, but I have bad ADHD, so I take an Adderall every morning.
oh,
So,
my husband.
yeah, I don't get hungry till 5 p.m.
That's him.
So,
Yep. I'm very familiar. trust me.
Gotcha. All right. I'll see you soon.
You.
I just saw you called a day or so ago, period. I have been in a jury trial all week in Fulton Superior Court. And then working on preparing for the next day till late every night. Period. Haven't really had a chance to look at my phone much this week. Period. How are things going with you? Question mark. The jury just started deliberating. So I'm just sitting here in the courtroom alone, nervous, period. Prayers are appreciated, exclamation point. You gonna go get something to eat?
I'm just gonna go to my car and get a smoke.
You smoke? I quit.
So I smoke so little that I should just quit,
Yeah,
but when I do these things,
no, I get it.
my wife smokes, so it's harder.
I quit years ago, but like when I can tell when someone's smoking like a Marlboro Light.
Huh?
And anytime I'm around, like my wife would be like, oh, that's so disgusting. And I'm always like, I'm like, dude,
Yeah.
I would crush a cigarette
I
right now.
rarely buy my own cigarettes. So
Mhm.
I mean, when I do this stuff, I'll probably smoke 3 or 4 cigarettes on the way down and back.
Yeah, yeah,
Especially
just to
for
ease the
driving.
nerves.
Yeah,
Yeah.
but otherwise, I maybe smoke 2 or 3 cigarettes in a week.
Okay.
Did she go to the
Yeah.
bathroom?
Do what?
Did she say she's going to the bathroom?
She gave me her cell phone. She went to go grab a snack,
Oh,
but if anything happens, I can text her to bring her back
okay,
in.
that's fine.
All right.
I'm gonna announce my car.
Yeah, I'll still smoke a little bit if I'm like having a drink or something,
That's the other.
or
thing.
somebody has them, but I can't buy them.
That's kind of where I draw my.
Because I know me. If I buy them,
Yeah, then they
I'll
have
be
a
like,
whole pack of mine.
oh yeah, it's like buying candy or like, sweets.
Exactly what it's
I'll
like.
start, I know me and I know like I'll be right back at it. So,
Yeah,
but
and about like 3 weeks ago, I completely quit. And I went like a month, and then I was like,
yeah. Plus just my physical, like my blood pressure's through the roof, my cholesterol's high. So I know I definitely can't start smoking again right now.
yeah.
I'm gonna make some like
I just
lifestyle
started having to
changes.
use a CPAP machine. I need to lose weight. I
Same.
just came back from the cruise, so I'm like, well, smoking is actually kind of helpful. So I rationalized that my number one enemy is the weight. So the enemy of my enemy is my friend. So cigarettes is my friend now. To
Yeah,
help
I
me
mean,
lose
it helps
weight.
you
To help me
take your
lose-
appetite away.
Exactly.
Who'd you cruise with? What cruise line?
Royal Caribbean.
Okay. Are you like a cruiser?
My 80-year-old dad lives with us, so he loves going on cruises, so it's
Okay.
kind of an easy vacation. And we had 7 people come with us, so
Yeah.
it's a pretty big group. So there's pluses and minuses to it. Like I never think you have enough time when you go to the ports to see actually anything.
Right.
But it's good in terms of you can be together, but not be together every moment.
Yeah.
You can have some of your space, but then still get together for dinner.
Yeah.
So that aspect of like my dad likes it. It's easier for him once he's on the ship, get around. He's good health wise, except for mobility. Only discovery that I found, we found him he's like a dog, it's like, food aggressive.
Mhm.
After eating a full dinner sitting down with us, he was sneaking back up to the buffet. That's what he made himself.
My son,
sick.
that was my
He
son.
made himself sick, but he's
Yeah.
80. He should know that by now. I
My
mean,
son ate like 80 grand worth of pizza, I'm pretty sure. At the, whatever the Sal's
I'm
or whatever
all
the
about getting
pizza.
it ready work, but my new theory is that I try to eat the most expensive stuff that I like.
Yeah,
Rather than quantity, I'm gonna go for quality.
Yep. I'd never been on a cruise till last year.
Oh, what do you think?
I loved it. I thought it was like awesome. I mean,
Yeah.
we took our kids and we got, we went Royal
Really
Caribbean.
kids.
I did Royal Caribbean and I got adjoining rooms on the top floor. So the kids, we could be alone and just close the little door in the middle. It was awesome. I loved it. And my
Yeah.
son's old enough, like he could do what if he was hungry, I was like, go
So
get pizza or something.
This was like our 6th cruise.
Yeah.
So they used to have a port in Mobile that was at least a 5-hour drive.
Yeah.
But they only had one option of one ship. So we've done Mobile, we've done
We had to go down to
New
Miami.
Orleans, we've done Port Canaveral, or Tampa, and
Yeah.
then and Miami. Miami's just a long haul. Then you get into usually
Yeah, it
really good
sucked.
flights. Did you drive?
We actually did. I thought, I didn't want to,
I
but
probably, well, actually,
I spent 10 grand on the cruise. Like we got the drink package, I got the kids the drink package so they could get like Starbucks and all that stuff. So and for the 2 adjoining rooms on like the 11th or 12th deck or whatever, I mean, it was like 10 grand for like a week-long cruise.
Mhm.
So yeah, I'm like, I'm not buying flights on
you
top
can
of
do
that.
it a lot cheaper. Like, we've gotten balcony rooms a few times, but
Mhm.
we spend almost no time in our rooms. So
Same here.
we started,
Interior,
that's what we.
I think I might do that next time. We never went out
It's
on
a
the
little
balcony.
helpful to have a window, at least because when it's the interior room with no window
Right.
and you're waking up, it's hard to tell what time of day it is.
We were never in the room anyway, like
We were
ever.
never in the room, other than really you need a place to sleep. And I like to gamble to a certain extent.
I did too. We gambled every night.
Yep, we gamble every night.
Vegas is like my
And-
favorite city on earth.
I got second place in the poker tournament.
Nice.
I was little, and I still had a prize,
Yeah.
but I was like that close to first.
Jeez.
But it's almost like it's better if you're like nowhere close at all. Or you're
Yeah.
close, but
I usually set aside like $300 a night. And then when it's gone, I'd leave.
yeah, I mean, everybody won. I won, my kids won.
Yeah.
My kids are older, so, and we've taught good lessons
Yeah.
in terms of when to fold and when not.
Do you ever go to Vegas?
I've been to Vegas a couple times.
Dude,
But-
I love Vegas.
I'm not a crazy gambler. I mean, I do it on occasion. On a ship, it's actually a cheap way to gamble because you play the poker tournament, you get so many hands.
Mhm.
Same thing with the blackjack tournament,
Yep.
you know.
I never gamble more than $1,000 or like for the whole trip.
I've discovered craps like 2 years ago.
Okay.
I've always watched it, like, didn't understand, but now I started to play it and I really like.
I've never played it because
It's
it
fun because
makes me nervous because I don't understand all the rules.
it is a little complicated, but everybody on the table is the same goal. I like games where it's
Yeah.
everybody versus the dealer.
Yep.
Or the ship. Cause then it's a happy table. 'Cause I don't like playing games where someone sits down, like sometimes having a blackjack, oh, you should have doubled down, or you should have took a card, you
Right.
could have stayed, you screwed up my card now. It's like,
Yeah.
so everybody's usually excited, because everybody wants the roller to keep rolling. I mean, you can bet against the roller or the shooter, but usually, no.
Yeah.
No,
Blackjack's
it's
my
fun. The
favorite
only
game.
thing I said, if I would do a European cruise,
Mhm.
I don't know that I would do a European cruise because by the time you pull into port, get off the ship, and then the time you gotta get back on the ship, and then allow a window because you're nervous about making sure you make the ship,
Yeah.
it doesn't give you enough time to see the stuff. Like the small islands in the Caribbean, it's enough time. You go
Right.
to the beach or do some small thing. But if you're going to Rome or you're going to like some of these places like that,
Yeah.
it's not enough time.
No, we did Royal Caribbean 2 years ago. Last year was my second time. My wife and I did a cruise to the Greek islands.
Mhm.
And
Yeah, what'd you think?
I'll never do it again.
Why
I mean, it
not?
wasn't terrible, but like we went to like Mykonos and Santorini. We were there for like an hour and a half.
So the issue that I was saying.
Yeah, I was like, I don't like it.
That was my fear.
That's different when you're in the
That sounds
Caribbean.
even smaller.
I
I
know.
was thinking you'd have, you come in at like 9 and you leave at 4 or something like that.
It wasn't even like that. Like you would, or maybe it was like 3 hours. We had time to eat
It
a
was
meal,
small window.
eat a meal, go to one shop and then back on the ship. I'm like, I wish, like I wanted to be there for a couple days.
Mhm.
So if we ever go back, I'm not gonna do that again. I'll take a ferry or a flight and just get a hotel or something.
Typically, when we would go to Europe, we'd go to Spain. Well, because my family's from Spain. They have relatives there, so.
Oh, that's awesome.
Yeah, we were in April last year. The whole group went, but we did do a tour. We didn't, Toledo is a great city to see in Spain because it's like 1,800 years old.
Mhm.
When you're walking around, you can't tell what century it is if there's no cars out.
Right.
On a particular day. I mean,
That's
it's just an
awesome.
ancient city. We also had a chance to, did you watch Game of Thrones at all?
I've never seen it. I feel like I'm the only one.
They filmed part of it, like one of the castles for Games of Thrones, was filmed at a city that was pretty close to where we were staying. My son found it. He's like,
Mhm.
oh, look, this is where they filmed it. So we went down, we got to see all that, which was kind of fun and cool.
Yeah.
I hadn't done that before. But I've been to Spain like, I don't know, 7 or 8 times.
That's
I used to
awesome.
go when I was,
You still have family there, you said? Oh, that's cool. So do you stay with them or do you get a hotel?
get a hotel.
Okay.
When I was by myself, 'cause I brought my family with me. When I
Right.
was by myself in college and stuff like that, I would just stay with them.
Yeah.
But I can't do that now with 5 kids.
Oh, yeah, I get it.
Nor, plus my aunt that I would typically stay with, she's 89 now.
Yeah, it's a little, it makes the trip different.
Yeah, but it's fun. I've been to France and stuff like that too. I have not been to England other than just changing flights. I
Right.
wouldn't mind going to England.
I've never been there either. I've traveled a lot too. I've only been to Paris once and it was just for a couple of days in town. Almost like an extended layover. I thought it was all right. I mean, the sights are cool, but the city didn't really impress me as much as I thought. It was kind of dirty. Everybody hated us. Like my wife and I, everywhere we went in, as soon as I was like, do you guys speak English? It was like, oh,
What year was it?
this was 4 years ago.
Okay, so fairly recent.
Yeah,
Well,
it was right before Notre Dame caught fire.
Okay.
So we got to see the Notre Dame Cathedral like before any of that happened. So it was still perfect.
We went there for our 1st year anniversary because I was like, it's paper. I'm like, what are we gonna do for paper? My wife's like, that's easy. We'll buy plane tickets.
Yep.
But that was a long time ago. I was like
Yeah,
26 years ago. 26.
that was cool.
Yeah, no, that was fun. But we stayed for a week. We actually lost weight on that vacation because we walked pretty much everywhere.
Oh, that's true.
And we actually found something, we weren't back. I mean, I love French food here.
Mhm.
I didn't enjoy it quite as much there.
Really?
I was totally moose.
Yeah, that-
Every dessert, every place seemed to be like moose.
Yeah, crepes, mousse, same kind
Went to
of.
the Moulin Rouge, that was a little tacky. We ate dinner on the Eiffel Tower.
I did that
Okay,
too.
but it wasn't the greatest meal.
Right. Yeah, you do that for the,
The best meal was
environment.
we went to Brussels. So we took the speed train for the day to go to Brussels.
oh, that's
Paris,
cool.
Which we bumped into another couple that said that's where they were coming back from.
Yeah,
So we were like, oh, that sounds like a great idea. So we did that. That's where we had kind of the best meal. was in
Yeah.
Brussels.
interesting.
Yep, I had like beer, Robert fried beer.
I mean,
It was good.
Belgian
It was
beer is
unusual,
known
it was
for,
great.
yeah.
Yeah, it was really good.
Actually, some of the best beer I've had is in Europe. I mean,
I'm not
just
a
to
big
bring
beer
it like,
drinker, but that was.
I'm not either, but I'm kind of a snobby beer drinker. If I do
Right.
drink it, I'll drink like a
Yeah.
good. And Belgian's light, and I like, most Belgian beer is light, and I like lighter, like ales.
All right,
But,
I'm gonna go my car, I'll get back.
all right, and I've got your number too, so if anybody comes back in here, I'll text you too.
I figured we'll probably have an issue with no, if anything, for another 20 minutes, half hour.
Yeah, they're probably still picking up 4-person.
I'll be back.
Sounds good.
I'll be back. Good job, by the way,
Yeah, you too.
any case, but.
You too. Yeah, my partner asked me how you did, and I said, actually, very well. I was impressed.
I got lucky on the motion for summary judgment. I think if you would have filed the motion for summary judgment.
I wish I had thought to do that
probably-
earlier.
Probably would have granted it for you,
Yeah,
probably. I don't know, still could be an issue on the table. That was the main thing. I mean, diminution in value of the case. I guess I never thought it was gonna get to this point.
Yeah.
Especially for this case.
right.
I always kind of assumed that we were probably gonna
Settle
settle
or
out of mediation or before that for some nominal amount of money. I'm thinking, okay, it's like 50, 60 grand. I wouldn't rent. Maybe we sell it for somewhere between 10, 20,000 bucks, 30,000 bucks,
yeah.
cheaper than doing this.
Your clients went through a lot, to be fair, and they were pissed. And I told you, like,
I get that.
it's easy to put my attorney cap on for American Capital Properties and like
No,
say
I-
everything. But I'll be honest, if I was them, I'd be pissed too.
Yeah, I know, but like you said, I mean, unfortunately, the rules are a little tougher, like Denise, she I tell her this stuff and I think she like just can't process it.
Yeah.
Like she just can't, the expression people hear what they want to hear. I'm telling it to her and I think that sounds like peanuts.
Right.
She's like, oh.
When I was reading the constructive eviction cases, I was literally thinking like, how's that fair?
I don't think
That's
that's the right,
crazy.
I don't think that's the right interpretation of permanent. That's the problem is that the script of the word permanent, because Florida went through the exact same thing in that case. Unfortunately, for your side of it, says exactly what I'm saying. Because if you read the first part of it, it's clear that what they're saying is it can't be something transient or
Yeah.
trivial. It's got to be something more substantial
Right.
and more long lasting. They should have used the word long lasting rather
Right.
than. I think they were trying to make it clear, but.
Yeah.
But
It should be like lemon laws for cars. Like you get 3 shots to fix something and then they have to buy your car back. It should be something like that. Like if you try to fix the roof leaking and it leaks 3 more times, they get to leave.
I mean, some of the older cases, there's just, some of the stuff is fact specific. I think that's why it's hard. That's why they kind of use rather than putting in a time frame. Because it's unique it can be unique for each case.
Yeah. Yeah.
All right, I'll see you in a little bit.
All right, sounds good. I'll text you if anybody comes in. Hey, I donated blood a couple of weeks ago, and my doctor should have sent you guys the therapeutic donation order, and I'm just calling to verify that you guys received it because I need to come in again this weekend. Seven 770-713-7496. 7496. Yes, ma'am. James Merritt, Merritt. And my doctor is Dr. Patel at Alpha Medical Clinic. I sent it to my doctor like a week ago, and then he called me like 3 days ago and said that he was going to send it. Yeah, no problem. I'll just call them and follow up. Thank you so much. All right, bye. Hey, I sent, this is James Merritt. I sent my a sheet in, like a therapeutic blood donor form in for Dr. Patel to sign and send back to Life South. And Dr. Raj Patel, he called me, I think on Monday, and talked to me on the phone after in the evening hours and said he was going to be sending it in. But Life South just told me that they still haven't received it. So I was just going to call to check on that. Perfect. Thank you so much. It's the Life South location in Lawrenceville. And I don't know if you need my date of birth or anything. That's the one. Thank you so much. All right, bye.
Is there any candy?
I don't think
I should
so.
have bought some chocolate.
You need some like sugar?
Yeah, I just, every time I eat lunch or dinner, which I
Yeah,
normally don't eat lunch, but I had a,
I think there's like candy bars and stuff in the vending machines, but I don't know.
I was just down there. They
Oh.
actually had a lunch guy, which was actually really good.
I've never even eaten down there.
Well, they bring it, it's like how a lot of buildings now are bringing people in.
Yep.
it was like you pick like a rice. And then a couple vegetables and a protein, it was good.
Yeah,
Yeah.
they have to, because they haven't had like a regular cafeteria here in forever.
Yeah.
And there's really not a lot of places to go eat around here.
No.
Like this is in the middle of nowhere for food options.
It is like a food desert.
It is. There used to be like a somewhat decent food court and underground,
Yeah,
but that's like a ghost town now.
I hate it. Yeah, COVID kind of. Well, a lot of these buildings too. A lot of the office like buildings and firms I go to.
Yeah.
Last time I was down in the vending machine area, I saw my ex's current wife and I was like,
Oh
I'm
my
out.
God,
I was like, God.
that sucks.
I was just like, I don't wanna, please don't talk to me.
That'll ruin your day.
You know, this town is too small.
Mm.
No, I'm good. I'm too like
You're good. I'm not trying to be extra. I'm like, you know how when we eat, I don't know if you have a sweet tooth.
Well, I gave up sweets and coffee for this.
Oh my God, both?
Yes. Double whammy. But I do feel clearer. I feel better.
I know, I need to,
But I understand. Yeah.
I feel like
Especially at the end of the year with the holidays.
I blew it out. I was like, what, who am I?
I
was eating Fritos. I don't eat Fritos. I was getting Fritos.
Happens to the best of us.
Fritos and dip. I don't eat that
And
stuff.
dip.
What am I doing?
If I couldn't have coffee, I wouldn't know who I am either.
But it is a slippery slope, right? Like, cause it makes you kind of jittery.
Yeah,
As
and then
I
the
drink
crashes, which I'm not getting now. And tea, they say that caffeine is released more slowly and evenly throughout the day.
Really? I didn't know that.
Misha drinks tea,
It's a
right?
good alternative. She does.
Yeah, she's not a coffee person.
Yeah. Well, thank you for that.
Sure. And thank you for the coffee.
No problem.
Speaking of, saving my life. Yeah, I don't know how you do Adderall and coffee.
I thrive.
It's my husband, like, but like, and he doesn't take as much as he used to, but sometimes in the morning, I'm like, I need you to blink.
Yeah.
He's just like,
I mean, sometimes if I haven't had anything to eat, then it's not a good combination. But if I time breakfast correctly,
he
then
doesn't
it's,
eat breakfast.
do what?
He doesn't eat breakfast.
Oh, no, if I didn't eat breakfast, I'd be like a crackhead or something.
That's how he is every day.
Yeah, that's, my wife would probably say that about me. What is?
The light's on. That means something, right?
The light's on? Oh, didn't see that. I think that means they have a question. Do they have a question?
Let's see where.
Did it just turn on?
Yeah, I think so. We both just noticed it.
Yeah.
We just did too. Oh, it's Liz. Are you with the jurors? Uh-huh, yeah, I just came on. Okay, thank you.
Hey, James.
Hey, the jury light just came on. I think they have a question.
Okay, I'm coming right back up.
All right.
And I just let Deputy Scott know, so he's gonna call on up and see what it's about.
Hey, the jury light just lit up in the courtroom, so the jury has a question.
Okay, I'll be back in a second.
All right.
Is it Mr. Devon?
No, he was the first guy I talked to. That was my
You
client.
let him know, thank you.
Yeah, yeah. Joe, what's going on?
Where's the jury light?
So that like light right
Oh,
there,
that's
it
true.
just lit up. And then Miss Sue came in and said that that means the jury has a question. So I just called them and told them to come back in.
Oh,
I'm interested to see what kind of question they would have after already having deliberated for an hour.
right.
Breadsticks for pizza.
Mhm. Rarely is it a question that can actually be answered.
It gives an indication of what they're thinking.
Sometimes the attorneys get nervous when the jury has a question.
Well, the judge just answered the question, can't answer it. He's not gonna ask you.
No, the judge will answer the question, but the parties and the attorneys have to be in here because we both have to have the opportunity to object to the way the judge intends to answer
Okay.
it.
It's the jury one meeting first.
Oh, no, the jury doesn't come back in here until they reach a verdict.
Oh, okay.
If they have a question, then they write it down on a piece of paper. The bailiff brings it into the judge. We go on the record. And the judge reads the question into the record, discusses with the parties how he intends to answer it, and there's a chance for us to discuss it. I mean, most questions.
The judge asked for the parties too?
Excuse me, sir.
I mean, not necessarily the parties, no. I mean, I don't know if your clients want to be in here for this or not. I don't really know what's going on.
Everybody can come back in.
Do the parties need to be in here or can the attorneys just,
I'm sorry.
does the judge want the parties in here or just the
Did they
attorneys?
leave?
They're somewhere around. Call them right
They
now.
can call. Only here.
My hands like, no. It's the nerve-wracking part.
You gotta come back up. Here, we believe the jurors have a question. And what the party talks about.
Do you guys on to eat?
Yeah. The bowl wasn't that bad. Much vegetables, rice.
Yeah, that's what the court board went down there and got and told me it was, yeah, they usually have something like that. Somebody brings in, like a vendor comes in.
Yeah.
I actually wish that this courthouse had like a nice cafeteria like Gwinnett County does.
Yeah, well, that's got a huge one.
I know, I love, and the food's pretty good.
Oh, really?
They'll make you a cheeseburger right there, fresh. It's awesome. But like DeKalb and Fulton are such big courthouses. They do so much business.
Yeah.
And there's no restaurants around here.
Yeah, I know. That's what, I looked at the map first, I pulled up restaurants, like, I
Yeah,
guess I'm staying here.
yeah. And Gwinnett Courthouse has like a nice cafeteria and they've got like 50 fast food options around there.
True, yeah.
It's right off of like Lawrenceville Highway.
Yeah. I've never been to DeKalb.
Yeah, I mean, DeKalb's not far from my office, but DeKalb's got options around it,
Yeah,
but I mean, it's not like super convenient.
yeah.
But yeah, it's surprising they don't like have cafeterias in all of the bigger courthouses like this. Not really.
Yeah, like a buffet.
Fulton County used to have a real cafeteria.
Oh, really?
Yeah, but they haven't for a while. They closed it. Now they just have like a common area
Yeah,
that sometimes, they'll have a food vendor come in and have limited offerings, but
yeah.
it's,
Who knows, maybe so. For it to be so small too, it's like.
There's a note or something.
Happy alarm.
Okay.
Like, what did we do?
Yeah, I'm like, what did I do, man?
It's one of those procedural things.
Yeah.
They
They found out what you did, James.
Yeah, I know. It's like, finally got him.
yeah.
Got warrants.
And it got.
There were additional warrants.
It's like, did I not put enough quarters in the
Yeah.
parking? Yeah.
It was
That
on-
ex-wife, she had it again.
I know, I think that I must have parked in like the
They'd have
Capitol
it
Police
just like
spot.
that,
or something.
everybody.
I was about to.
That was good. A lot of cops in here. I don't know.
It felt like you were talking to me at the red light.
And I've been in a lot of court questions. I've heard a lot of courtrooms. Actual issue.
Yeah.
Which I've only seen that happen a couple of times. That'll make you nervous.
Showing up.
One of the worst, James, is waiting on deliberation for capital cases.
Oh, I know. I'm sure. Good Lord, I couldn't deal with that kind of pressure. Have you ever seen, I mean, you've done criminal work. Have you ever seen somebody like try to rush the bench or some outburst in
In
court?
Pennsylvania, we did.
Wow.
Punch the judge in the face.
Wow.
They
Wow.
made it all the way there. And they changed some of the rules because back then, they had like five deputies that were like.
Yeah.
Not gonna stop anything, and didn't stop it.
Yep.
Actually, the lawyers.
There, I tried a couple of cases in Glenn County in Brunswick. And both times in Superior Court, the only bailiffs in the courtroom were like senior citizen volunteers. Like an old guy in a sweater vest that was like 85 with like a paper like volunteer badge. And that was the only bailiff. There was no law enforcement, which it was a civil case, so it wasn't that concerned. Yeah, but like, yeah, I'm just thinking like, there is no security in here. Like this guy's not stopping anybody, not here.
I know, so y'all had a verdict and no security showed up?
No, I was in Glenn County. I've tried a couple of cases down there and both times the only bailiffs in the courtroom throughout the trial were like senior citizens that were like volunteering.
My mom was only in real.
Yeah, like they had to be like in their 80s. And I just remember thinking like, these people aren't gonna stop anything if something happens.
They might get in the way,
Yeah.
like you
Maybe.
hide behind them.
We.
They might fall.
Or if it ain't like, we don't care if it's minor. or
Is this a
what.
verdict or a
Yeah.
no?
Yeah.
Do what?
Is this a verdict or a no? We don't know.
Oh, no, I think it was a question. Miss Sue came in and said the jury had a question.
Did they tell you it was a verdict?
Oh, maybe it's a verdict. I thought they had a question.
That was quick.
I
Yeah.
saw a guy get arrested
God,
last
that would be pretty quick.
year.
Just an
It was
hour.
that 11:45 nightclub shooting.
Yeah.
It was a civil case.
Uh-huh.
I was there for because I don't do any criminal. And
Yeah.
the same exact thing happened. A bunch of Deputy Avila,
Uh-huh.
bunch of deputies came in. And all of a sudden, the judge was like, hold on, and went to the back and then came out and they arrested him on a completely different charge that he had a warrant for.
Wow.
He had a warrant, y'all were gonna.
I was sitting there
Jeez.
like, what do we do? Yeah. Yeah, but see, like, when we do depositions, we don't have y'all. And I've seen people almost in law offices, like, getting those fights and.
If you find what he found.
So it's just a no or is it a verdict?
Oh, it's a verdict. Wow.
They're on the way. They should be here any minute. So, especially with the verdict, so
How do we deal?
So we appreciate you guys.
They've done a bifurcated trial.
Be careful.
God.
I would assume that in the event they come back and they say, finding for the plaintiff, I guess, and they check mark off plaintiffs, then they're gonna send it back again to the deliberate and decide on punitives.
I don't
I
know,
don't
like,
know that we need any testimony on.
punitives aren't even mentioned on this verdict form. Unless I'm missing something. I thought he was gonna address that like separately, depending on whether or not there was any liability for the two.
May I see the court come to order?
No, my clients are on the way up. I just spoke to them just a moment.
Do they want to wait? They don't want to,
Yes.
that's fine.
I thought first it was a note, so if it was just a note, I would.
Deputy Scott tells me they've reached a verdict.
Judge, and I had just I guess a housekeeping question, because I've never done a bifurcated trial in my career. So if the jury finds liability on one of the two towards that, to which punitives can attach, how do
I thought it was
we?
only one. We only, the way I've got that verdict structured, the verdict form structured, it was just, if you found on count 2, you consider punitives, not count 3.
Oh, I see that. So, but I mean, if they select yes for the punitives, how do we do what
Then
happens
we
next?
would tell them to go back to the jury room and
Finding amount?
you'd have the opportunity to present further evidence. Both
I wouldn't-
sides would.
Yeah,
Then we'd go right into another round of closings and I'd have to come up, show you the jury instructions we use for punitive damages.
got it.
So there'd be some housekeeping to consider.
Yeah, because we're on the other side of the tower.
Right.
We weren't expecting you to call so quick.
All right, you ready, Ms. McKee? Okay. We are back on the record and I believe the jury has been deliberating for a little over an hour. They worked through lunch and Deputy Scott has informed me that they have reached a verdict. And so unless there's anything to take up on behalf of either party, we'll retrieve the jury.
Back to the jury.
Thank you, Deputy Scott. Please be seated, everyone. Members of the jury, Deputy Scott has informed me that you have been able to reach a unanimous verdict. And so I would ask the foreperson to identify themselves by number for us.
Juror number 4.
All right. And juror number 4, have you reached a verdict?
Yes.
Was it unanimous?
Yes.
Has that verdict form been filled in, signed, and dated by you?
Yes.
And you can hand that to Deputy Scott so I can inspect it. And juror number 4, I would ask you now at this point to publish the verdict by reading it aloud for the record.
Okay. All right. So we, the jury, find as follows. For number 1, as to whether the defendants breached a contract with the plaintiff, we, the jury, find in favor of the plaintiff as to HYH Consulting LLC. We, the jury, find in favor of the plaintiff as to Bo Yun Han and Yang Ha Han. Do you want me to read the bottom down, the damages, or?
If you would.
Okay. We are awarding actual damages of $118,937.89. As to the, for number 2, as to the plaintiff's claim for voidable transfer, we, the jury, find in favor of HYH Consulting LLC. We, the jury, find in favor of Hank Corporation. We, the jury, find in favor of Bo Yun Han. We, the jury, find in favor of Yang Ha Han. For number 3, as to the allegations of breach of fiduciary duty, we, the jury, find in favor of the plaintiff as to Bo Yun Han. We, the jury, find in favor of the plaintiff as to Yang Ha Han. For number 4, as to whether the defendants acted in bad faith, has been stubbornly litigious, or has caused the plaintiff unnecessary troubles or expense to warrant reasonable attorney's fees and expenses of litigation, we, the jury, find in favor of the plaintiff.
All right. And if you could hand that back to Deputy Scott. And for counsel, the verdict form is available for your inspection if you would like to review it. If not, or at the conclusion of your review, I would ask if there's an objection to the form of the verdict.
Objection from me, Judge.
No objection for me.
At this time, is there anything further required of this jury on behalf of the plaintiff
No, Your Honor.
and on behalf of the defense?
Question for the jury.
All right, members of the jury, at this time, I'm going to call on each of you by juror number, and I'm going to ask you 3 questions. And I'll start with juror number 4. Was this your verdict in the jury room?
Yes.
And was it freely and voluntarily made by you?
Yes.
And is it still your verdict?
Yes.
Juror number 11.
Yes.
I think just raise a hand for me. Thank you. Was this your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Juror number 13. Was this your verdict in the jury room? Was it freely and voluntarily made by you? Is it still your verdict? Juror number 15. Was this your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Juror number 16. Was this your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Juror number 18. Was this your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
And is it still your verdict?
Yes.
Juror number 20. Was this your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Juror 21. Was this your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Juror 22. Was this your verdict in the jury room? Was it freely and voluntarily made by you? And was it still your verdict? Juror 28. Was this your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Juror 29, was this your verdict in the jury room? Was it freely and voluntarily made by you?
Yes.
And is it still your verdict?
Yes.
Juror 31, was this your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
And is it still your verdict? Anything further on the part of the defense? Members of the jury, at this time, your service has come to an end. And if anyone wants to speak to you about the case, or if you want to speak to anyone else about it, you're certainly free to do so. But that is up to you. There's no requirement that you do so. And if there are any more excuses you need for work, we can handle that with Mr. Derryberry before you leave. And also, when we send you back to the jury room to collect your belongings, I know I'm going to want to come back and thank you personally. I also typically like to give counsel the opportunity to come back and solicit feedback. A lot of times it helps the attorneys to be able to hear what was on your mind, how you came to this decision, and provide any constructive feedback just about the lawyering process as well. Again, certainly not obligated to do any of that because at this point, you are free to go. Thank you so much for your time this week.
All right.
All right. We will have a final judgment prepared and likely filed before the end of the week. And so unless there's anything further for the purposes of the record, we'll consider this matter adjourned. Anything on behalf of the plaintiff?
No, I'm assuming the court will prepare the final judgment? Okay.
We'll prepare one.
Sounds
Unless you feel, if you want to send a proposed one because you want a particular language, feel free. In fact, let me go ahead and solicit that. If you could send a proposed order, and can you do that by the end of the week?
Sure, absolutely.
All right.
Send it to Mr. DeBon first to review.
Just CC Mr. DeBon, and he can weigh in if he has clarifications or if he has anything he thinks is objectionable. Anything further on behalf of the plaintiff?
No, Judge.
All right. I'll note exhibits here as well to whichever party feels like they need to keep track of those or keep custody of them. Anything further on behalf of the defense, Mr. DeBon?
I would just renew my directed verdict in the form of a judgment notwithstanding the verdict.
All right. I'll consider those renewed and preserved, and I would address those in the final judgment order. Then with that, we'll consider this matter adjourned, and we'll be off the record. All right. Thank you, counsel, for your work this week and for your professionalism.
Thank you, Your Honor.
That's up to them. I don't know.
Got the 3/4, I think it was 5.
5. Yeah, some of them are in that stack right there.
I would rather, just in case we need the transcript, that record is complete already.
Did either counsel want to meet with the jury, by the way? You don't want to? Mr. DeBon, did you want to speak with the jury at all? All right, well, I'm going to go talk to him first, just to give him a heads up.
I never have either, and I've tried like 25 or 30 cases, but I think they do get included
Were
with the
there
record.
2 or 4 and 5 that are taken?
Well, 4, yeah, so I don't know. 4 was with the jury charges. But right now, just deal with those.
I'll just, and then leave all of these.
I would take all of those,
I just
including
don't wanna
those.
do anything.
Yeah, I would take
Always return.
jury 3.
That was, those were, yeah, those are the ones on the desks.
Yeah, I just would leave all of those and just take all of those.
All right, I'm just gonna take this whole stack.
Perfect. Thank you so
Are
much.
y'all splitting tape down?
We are 50-50. Mm,
I thought so, yeah,
yes,
figured I'd ask.
thank you so much.
Thank you, guys. Pleasure. All right.
All right, hopefully Jonathan will be pleased. I'm gonna email him, let him know about copy you.
Yeah, I was curious what they thought.
Oh, I mean, you wouldn't have been able to go back there. Yeah, I don't think that. So, yeah. All right, I'm actually at the end of the office. Yeah.
All right, thanks.
Yeah, you too.
I can,
Bye.
See you guys.
Hi, James.
thank you.
Bye.
Bye, James.
Bye. See you guys.
See you.
Just don't know how history, let's know if any, what the probably just have to go with. Payment, almost.
What are we talking about here?
$250,000.
They're over like 270. I'm just.
Counselor, you come on back.
I'll talk to you.
What are you talking about?
Yeah.
All right, bye, guys.
Take care, nice to meet y'all.
Thank you.
All right, thank you.
Thank you.
Yeah, take care of.
Yeah.
Yeah, I tell you, I was here for that whole thing. I had no idea what this was about. It's like,
Did he, plan it enough?
it was pretty quickly.
Yeah, that was this. I don't know, like I said, over an hour.
Yeah.
They went straight through without a question.
I know. Probably ready to go.
Thank you for your service.
There you go.
Thank you for your service, sir. Thank you so much. All right, sir. Thank you for your service. Man.
Oh, she's not doing.
How you doing, sir? Thank you for your service. Take care.
Thank you.
Thank you.
All right, thank you.
Oh, my gosh.
That one.